Good afternoon, one and all. I'm Chandana HP, a fourth-year law student of Alliance University and the Vice President of Alliance Center for Intellectual Property Rights. On behalf of Alliance University and Alliance Center for Intellectual Property Rights, I take the pleasure of welcoming you all to the National Workshop on Recent Trends in Intellectual Property Laws. As you all know, today is World Intellectual Property Day. So as an IPR center, we have taken this initiative to spread awareness and knowledge about IPR through this workshop. We have received a huge number of responses. We thank you all the participants for showing keen interest. And I'd also like to thank all the guest speakers who will share their valuable knowledge with all of us today. For all those who have not been able to register, we are also streaming it live on Alliance University official YouTube channel. Kindly share this information with your peers as well. We will now begin with the workshop. We first have Dr. Anubha Singh, an inspiring and motivating Vice Chancellor of Alliance University, who will be addressing the gathering with a welcome note. Dr. Anubha holds a PhD from Banaras Hindu University, a certification in computational linguistics from Indian Institute of Technology, Delhi, and a certification in natural language processing from University of Hyderabad. She has also earned the prestigious Jawaharlal Nehru Memorial Award for academic excellence during her post-graduation in linguistics. Dr. Singh, a talented coalition builder, brings significant expertise and rich experience in international development. She has established 47 partnerships with reputed universities in 15 countries and has been very effective in making significant contributions in the field of sustainable global development. Dr. Singh strongly believes in education's key mission, which is the creation of a job-ready youth. I now request Dr. Anubha to proceed with the welcome note.
Thank you very much, Chandana. Good afternoon. It is my distinct pleasure in welcoming you all to the National Workshop on Recent Trends in Intellectual Property Laws, organized by Alliance University's Center of Intellectual Property Rights on a very important day, World Intellectual Property Day. At the outset, I would like to express my profound gratitude and a very warm welcome to our distinguished guests for accepting our invitation to be our speakers and share their expertise. I would particularly like to express a warm welcome to Shri G.R. Raghvendra, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India, Ms. Bindu Sharma, Founder and CEO, Origin IP Solutions, Veteran Wing Commander Shivram P., Senior Corporate Counsel, Cisco, and also our PhD scholar at Alliance University, Mr. Gaurav Singhal, Principal IP Attorney, Singhwal Tech Law OPC Private Limited. I would also like to acknowledge my fellow colleagues, Pro Vice Chancellor Academics and Research, Dr. Ray Titus, Dean School of Law, Dr. Kiran Gardner, professors of Alliance School of Law, our faculty members, and our dear students. I'm deeply humbled that large number of participants, including distinguished officers of Government of India, members of legal fraternity, IP practitioners, academicians, professionals, research scholars, and law students are attending this workshop today. Every April 26, WIPO celebrates World Intellectual Property Day to learn about the role that IP plays in encouraging innovation and creativity. This year's theme, Intellectual Property and Small and Medium Enterprises, taking your ideas to market, is focused to build stronger, more competitive, and resilient businesses. The groundwork activities of Alliance Center of Intellectual Property Rights have been ongoing for some time now. The initial plan was to launch the IPR Center on the university campus. But in the current situation of severity of COVID outbreak, our law school dean, Dr. Kiran Gardner, with the Center of IPR faculty members, Professor Umpankar, Professor Abhishek, Professor Yamani, and the student team are launching it virtually with a great deal of zeal and enthusiasm. Last week, I was in a conversation with three of our law students. You heard Chandana. So Chandana Rishikesh, and Omkar, who were working very enthusiastically for the IPR Center and for this workshop. And I was inspired and enthused to learn about their passion towards IP, their commitment to their academic pursuit, and the career path that they have chosen. Well, today, IP is related to our life, to your life. We live and breathe IP. There is plethora of IP around us, embedded in our personal and professional environments. And let me tell you what this means today. So before heading outdoors, people ask Google Home for the coronavirus situation or restrictions in the city. Do you know about the patent behind Google Home's feature of understanding different voices? The trigger phrases, OK Google, Hey Google, are officially considered hot words in their patent filing. We tap our Apple Watches to send emails, to reply to messages, and even pay for groceries. Well, the watch is a masterpiece of intellectual property and has several design patterns for every detail: the crown, the drawer where the watches are shown, the bracelet, the slide in interchangeable strap system, the digital crown, the display, the charger, etc., etc. And there is one thing we cannot live without, and that's mobile phones. These are protected by layers and layers of some form of intellectual property like trademarks, patents, copyrights, designs, semiconductor integrated circuit designs, and so on. The brand names are protected as trademarks, the logo of the brand, the words associated with the logo, the color combination used, the shape and size, these are all protected as trademarks. The sensors, the networking and data storage technologies, even the case of the mobile phone, its water-resistant material, are all protected by patents. The system on the chip, the layout of transistors and circuits are protected by semiconductor integrated circuits design. The source codes underlying computer programs that are applied to the phone are protected by copyrights. So just see the range of intellectual property rights that one finds in the smartphones. And that's why IP plays an essential role in everyday's life. It also plays an essential role in teaching and research functions of universities. Alliance University has believed in creating new knowledge through basic and applied research. Many of these research and development activities are patentable. The IPR Center resonates with our passion to do more as a university and as an entity to create knowledge, to promote scientific research and technological development. Identifying and creating IP and bringing research results to the next stage of development is our objective, and that is through the center. With this platform, our aim is to provide an environment that supports and encourages innovation and development, produce results in the form of inventions, and generate intellectual property for all our research and development and scholarly work, including teaching activities such as thesis, software, designs, and even teaching materials. As a university, we have carved a space for ourselves and aspire to be among the top global universities. The National Workshop on IPR will provide an opportunity to have the leading IP experts share the know-how and practical tips on how to create IP assets, how small and medium enterprises can use intellectual property to advance their business goals and gain competitive advantage, covering a broad spectrum of topics such as copyright infringement and digitalization for educational institutions, patents to boost innovation, artificial intelligence and patents, trademark filing trends in India, and recent judicial interpretations on trademark laws and principles. Thank you for the interest that you have shown in this important event that will undoubtedly generate lots of interesting results and new intellectual properties. I'm sure that this effort will have a great impact on IP creation, impact on economy, societal benefits, and of course, brand enhancement. I would leave this platform with the belief that all of you will thoroughly enjoy the day in discussing beautiful topics around the workshop theme. I wish you all an exciting and valuable knowledge exchange in this workshop. Thank you very much.
Thank you, Dr. Anubha, for a very warm and informative welcome note. We now have Dr. Ray Titus, who will be addressing the gathering. Dr. Ray Titus is the Pro Vice Chancellor of Academics and Research and a professor of Alliance School of Business. He holds a doctorate in business administration from SMC University, Switzerland, and an MBA from the International Management Institute, Belgium, and has taught courses as a visiting professor at IIM Bangalore, SP Jain Center of Management, Dubai and Singapore, Asian Institute of Technology, Thailand, and the Institute of Product Leadership. Dr. Ray is the founder of Dabbit Lab, a digital habits research lab that uses mixed method research techniques to generate depth-driven user insights. Dr. Ray has also authored 3 books. I now request Dr. Ray to address the gathering.
Thank you so much, Chandana. Good morning, everybody. At the outset, let me acknowledge the presence of my esteemed colleagues, Vice Chancellor Dr. Anubha Singh, Dr. Kiran Gardner, who heads the School of Law, distinguished speakers for today, my faculty colleagues at the School of Law, attendees who probably from the faculty community and the industry community. Welcome to this workshop, and thank you for being here. As you are awaiting the start of the sessions and the distinguished speakers are going to speak on the various facets of IPR, I thought it would only be pertinent for me to present a counter view to the concept of intellectual property rights. And in presenting that to you, I'm also going to remind you of the fact that many of the products that you use in your everyday life are what we call in the software, in the tech domain, open source, products or open source applications. For example, you probably have used the Chrome browser maybe just a few seconds ago, maybe a few minutes ago, and probably you get on Facebook, probably use notepads, etc. Products like this. If you've done that, then I can tell you that you are part of what is called as an open source movement. An open source movement is a counter to the proprietary movement. In fact, Internet Explorer, the most famous browser until a few years ago, is a proprietary software, whereas Google Chrome is an open source software. Now, I believe that we have come to a point in time where we have to find the balance between the proprietary kind of a movement and the open source movement. And I'm just going to leave you with a few thoughts on this so that you keep that as the backdrop to everything that you listen in terms of intellectual property rights. It was in the year 2006, that's almost 15 years ago, that I first got onto the open source movement or leveraged the benefits of the open source movement when I started my blog called Buyer Behavior. It was 2006 that I started writing that blog, and I've been writing that blog ever since then. The last few years, of course, my blog writing has gone down simply because I've invested more time to writing books. I have actually seen both sides of the coin, the open source side and the proprietary side, because my blog is built on a Blogger platform, which is an open source platform. And the books that I wrote, and I worked with two main publishers, one is Penguin and the other one is Sage. The books that I wrote are copyrighted. And so the material that has been created belongs to me. It cannot be used by anybody else. I've protected it, and I've tried to monetize it by having the publisher put up the book for sale. And the books have done pretty well. So having seen two sides of the coin, I want to leave you with a few thoughts about the open source movement. And I'm going to then provoke you to think about how you can marry the open source movement with the proprietary movement and find a sweet spot, which is a blend of the two. And I think Chrome represents that blend to perfection. So let me first give you the principles that drive the concept of the open source movement. And these are principles that seem contrary to the proprietary movement, though I fundamentally don't believe they are proprietary. But listen to the 4 principles that drive the open source movement. The first of which is the concept of abundance. Open source fundamentally believes that the pie is not a fixed sized pie. that the pie can be grown larger, and we can take chunks out of the pie, and each of us can benefit, vis-a-vis the conventional thought which says the pie is fixed, it has to be shared, it's a zero-sum game. If I get a slice of the pie, you don't get a slice of the pie. The open source movement, on the other hand, believes that the pie can be grown and it can benefit anybody and everybody who wants to partake in the making of the pie, in the monetizing of the pie. So abundance, the concept of abundance, drives the principle of open source. The second concept that drives the principle of open source is vulnerability. Every time you create work that you believe needs to be protected, and you step away from that protected nature of the work that you've created, and you put it out there and tell other people to judge it, to critique it, to build on it, you expose yourself to a certain level of vulnerability. The open source movement by default requires you to become vulnerable. Vulnerability is not weakness. Vulnerability is the courage to put work out there and tell other people to build on it, to critique it, to add to it, and to make it better. If open source is driven by the concept of, or the mindset of abundance, that all of us can participate, it is also driven by the mindset of becoming vulnerable. Vulnerability is the second value or principle to open source. The third one is collaboration. The collaborative mindset is one where you say, I have to participate with others to create a body of work that I will then open up to others, not just to use, but also to build on it. Collaboration again drives the concept of open source. It says, and open source software has transformed our lives. We know this. We use this day in and day out, right? So let me repeat the three principles that I've told you till now. One, we're driven by the mindset of abundance, where we say the pie is not a fixed pie. It can be grown. It can benefit anybody. And these are not socialist principles. I'm a free market capitalist, so I don't believe in socialist principles. This is a principle of abundance, where we say everybody can participate, everybody can get a piece of the pie. And two, it requires you to put your work out there and become vulnerable. Three, it requires you to collaborate with others. And finally, any open source movement requires people to take initiative. You've taken that first initiative, somebody else takes an added initiative, and then somebody else follows up with his or her own initiative. And this is a movement. It's a movement where multiple people take initiatives forced by none on their own. And so if there are those four guiding principles of the open source movement, it's about abundance, it's about vulnerability, it's about collaboration, and it's finally about initiative. However, how does this movement survive when we're talking about intellectual property that has to be secured, that has to be monetized, because the value that is derived out of that property must accrue to the person who's created that property? How does it survive? And the best answer to this is I would pick up Google Chrome as the best answer. Google Chrome is classified or characterized as proprietary freeware. It's a freeware. You get it for free. However, it's proprietary. It belongs to Google. The monetization models are unlike what Microsoft has done. Microsoft's monetization models in most of their products comes from, if you want to use their products, you got to pay for it. Google says, no, you can use our products, because these products have not just been built by us. This product has been built by millions of people sitting around the globe, writing a patch of code, testing that patch of code, making it better and better and better. And today, even though Microsoft has replaced Explorer with Edge has got 3% of the market share, when Google has got 64% of the market share. It's 6 out of 10 people use Chrome to browse. How does Google make money from its proprietary freeware? One, through advertising and no royalty payments to browsers. Two, by connecting that product, that proprietary freeware, to other products that Google has in place, whether it's Gmail, whether it's any other product, whether it's Meet, whichever product that Google has, it connects the Chrome browser to those other applications, allowing us to navigate via the browser to other products. And those products have got monetization models built behind it. So today, as I leave you with the opportunity to listen to all of these wonderful speakers. What I want to tell you is that we have come to a point in time, and we know that the COVID situation is grave now with the vaccines out, and there's so much of debate around whether the vaccines should be free, not free, etc. And we know intellectual property is so, it drives the pharmaceutical industry. We know this. I believe we are at the cusp of a time. We are at the cusp of a movement where we're going to marry the value that comes from creating intellectual property to distributing that property, to making it available to others using these principles, these 4 principles, and yet building a monetization model where the creators benefit, where the collaborators benefit, where the contributors benefit. So I want to leave you with that thought as you listen to these distinguished speakers speaking to you about different facets of intellectual property, that we've got to be able to marry the open source movement with the proprietary movement. And the best example of that marriage is a proprietary freeware called Chrome. Thank you all for your time. I hope you have a great day ahead. Thank you.
Thank you, Dr. Ray, for a very insightful contribution to IPR. We now have Dr. Kiran, who will provide the workshop opening remarks. Dr. Kiran is the Dean of Alliance School of Law. She holds a PhD in law and a PhD in education. Dr. Kiran has more than 3 decades of academic experience and has contributed immensely in the field of law. Her areas of interest include criminal law, constitutional law, gender studies, and research methodology. She has also actively contributed to police training programs in the areas of Juvenile Justice Act, Protection of Children from Sexual Offences Act, Domestic Violence Act, and in the amendment of criminal laws and bail provisions. She has also delivered various lectures on sexual harassment at workplace, women empowerment, and right to information and women's right to maintenance and property. Dr. Kiran has previously edited books and is currently an editor of many journals. She has also organized various national and international conferences, faculty development programs, and moot court competitions. Under her guidance and support, the ACIPR Alliance Center for Intellectual Property Rights was initiated, and she is also the editor-in-chief of our newsletter, the ACIPR Bulletin. I now request Dr. Kiran to proceed with the session.
Thank you, Chandana. It's a pleasure to welcome everyone, and I'm so very thankful for all of y'all that you have taken up time to be part of this workshop. Well, I would just talk a little about how the center came into being and what was the thought process behind bringing up this center. We at Alliance University do offer an honors program for the UG, that is undergraduate program in IPR. And we also offer IPR as a specialization for LLM program. So what we have been doing is, yes, that we are teaching all the courses at the UG program as well as at the LLM program. And what I saw that in our research projects, a lot of students are doing very good work. And then that remains as a project and it doesn't go further. And as I look at students who are so promising and my faculty members who are also so very young and dynamic, I thought that why don't we take this program to another level where the students will be able to do research and be the part of creating new knowledge. And what I also saw was people from the industry. They're very keen in sharing their knowledge. Like I would say wherever to whomever I talked, nobody said it like, that they don't have time or they will not be able to. And I'm so very thankful, like, from their busy schedule also, they have taken up time on the weekday to be with us and to share their knowledge. So I'm really thankful to Mr. Raghavendra, the Joint Secretary, just everybody, whether it's Bindu Sharma, or whether it is Shiva Ramakrishna Prakash, or whether it is Mr. Gaurav Singhal, they were just one phone call away. I just asked them whether you would be able to contribute to this workshop, and they were there. And like when I discussed with some where we could have some collaboration and whether we can do some research or have some project together, I saw that they were interested in contributing and also there to share their knowledge. So what we are planning in the days to come, that as we see that there is a great interest among people to know more of IPR, and today more than 1,000 participants have registered for this workshop, and we then opened it to the YouTube channel so that many more can take the benefit of this. So we want to have such workshops, symposiums, some seminars for dissemination of knowledge relating to IPR. In the days to come, we are looking for some short certification courses or diploma courses in this area. And we also plan to have an incubation center in collaboration with industry professionals. And also we plan to write some practical books in this area, bring out newsletters and journals for the benefit of people at large. I would like to really thank my faculty members, Dr. Upankar, Professor Yamini, Professor Abhishek. Especially, I would say that a few days ago, we were not very sure how are we going to do this. All of a sudden, while we were really working hard, and Dr. Upankar suffered from COVID, and he was not able to work, and we were wondering how are things going to be, and he's back with the same vigor. So with such dedicated faculties and students, I'm sure this project is going to be a great success. Thanks a lot once again, everyone, for your having trust in us, and we will try to give our best in whatever we do. Thanks a lot. Have a very good day.
Thank you, Dr. Kiran, for providing the workshop opening remarks. We now have Professor Abhishek Sharma to give an introduction about the ACIPR newsletter. Professor Abhishek is an assistant professor at Alliance School of Law and holds an LLM degree from Gujarat National Law University with specialization in IPR. I now request Professor Abhishek to proceed with the introduction.
Thank you, Chandana. Am I audible?
Yes, sir.
Okay. So, first of all, a very good afternoon to all the dignitaries, speakers, and participants. It is my pleasure to welcome everyone to the National Workshop on Recent Trends in Intellectual Property Laws. I also thank you all on behalf of Alliance Center for Intellectual Property Rights for joining us to celebrate World Intellectual Property Day. We know that India is a breeding ground of many creative minds, and the Alliance Center for Intellectual Property Rights, that is ACIPR, which is an initiative of Alliance School of Law, Alliance University, is focused on those creators and supporting their creations through active research, promotion, and protection of IP rights. With exploration of human ideas, there is continuous development in technology, and such developments are adding more unexplored areas in the IP domain. So ACIPR will give special attention in encouraging research and development in those unexplored areas of IP. On this occasion, I also take the pleasure to announce that ACIPR has come up with first volume and first issue of newsletter, that is ACIPR Bulletin. I thank Alliance University, Dr. Anubha Singh, VC of Alliance University, Dr. Ray Titus, Pro Vice Chancellor of Academics and Research, Dr. Kiran Dennis Gardner, Dean of Alliance School of Law, my colleagues and students who helped us to make this dream come true. ACIPR Bulletin is a bi-yearly newsletter. The first issue contains current national and international issues. The contents of the newsletter is diverse within IP domain, which will keep the readers well informed. The newsletter also contains various fun facts of IP as quick facts. These will serve as refreshment for the readers and will keep them refreshed throughout the newsletter. So now, with permission from all the dignitaries, I am unveiling the newsletter, that is ACIPR Bulletin. So this is our ACIPR Bulletin, our newsletter. And you can find the link of this ACIPR Bulletin within our website, Alliance University's official website. So you can go and look into the newsletter there also. Thank you, everyone. Have a nice day.
Thank you, Professor Abhishek. We now have Mr. G.R. Raghavendra, who will be addressing the gathering on the topic copyright infringement and digitalization for educational institutions. Mr. G.R. Raghavendra is the Joint Secretary of the Department of Justice under the Ministry of Law and Justice since 2017. He is the Mission Director for the National Mission for Justice Delivery and Legal Reforms. He is also driving policy reforms for improving enforcing contracts parameter under the Ease of Doing Business and E-Codes project. Mr. Raghavendra is the former Registrar of Copyrights of the Indian Copyright Office. He played a key role in introduction of the recent amendments to the Copyright Act 2012 and the Copyright Rules 2013. He also made significant contributions to two WIPO treaties, namely Beijing Treaty on Audiovisual Performances 2012 and the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled 2013. He has also contributed in revision of the copyright legislations of Bhutan, Cambodia, Myanmar, and Nepal as a copyright expert and is currently pursuing PhD in IPR from GGSIP University, New Delhi. I now request Mr. G.R. Raghavendra to proceed with the session.
Good afternoon, everyone. Namaskar, and congratulations on World Intellectual Property Day today. And I would like to thank Vice Chancellor of Alliance University and Pro Vice Chancellor and Dean, especially Dr. Kiran Gardner, and all your faculty members, researchers, and students, and other viewers attending this World IP Day conference organized by your law school, and especially during this unprecedented difficult times. You have taken time to recognize the importance of this day, and especially to instill the awareness of intellectual property rights, not only in the minds of young creators and right owners, and also instill the respect towards intellectual property rights among others is very, very important. So I request all of you, more than 130 who are attending this event, to choose at least one person whom you can educate on the importance of intellectual property rights, and especially the copyright, and how important to how it's important to respect the creators and the interest of right owners. And you know that during this lockdown times since last year, and how people have been accessing to content, various kind of works. It may be the printed books or articles or various entertainment videos or films by becoming a legal member, or a legal subscription you're taking by making some amount to various platforms like Netflix or Amazon or Hotstar. So you are seeking entertainment and knowledge and killing your attention imposed by this COVID pandemic, and also educating yourself, buying various books and subscribing to various platforms which provide copyright content. So it is important this day that we take a pledge to instill the respect in at least one person about the importance of copyright and other intellectual property rights. So again, congratulate Dr. Kiran Gardner and our team holding this conference, and especially the topic copyright infringement and plagiarism during this digital environment is very, very relevant, not only to the teachers, researchers, students, and everyone who are listening this session. So you're all aware that what copyright is. So copyright is a legal right, an exclusive right given to an author whose original creative expression or idea, which is fixed which comes out to you in a fixed form, in any form or in any manner in which copyright subsists. Copyright works may be the literary works or artistic works or musical works or dramatic works, and sound recordings and cinematograph films. There are related rights like performer rights and broadcasting rights. For instance, why performer right is a related right? Because the performer sings, the singer sings already existing literary work in which copyright subsists, and that performance is accompanied by musical work in which copyright exists, and the author of that musical work is music composer. So in the digital environment, those same rights and the same copyright protection, the authors of these works, whether literary works or musical works or sound recordings, a cinematograph film, or even performers' right, have to be extended to even digital environment. So question came in 1996, how this has to be done. The World Intellectual Property Rights, on whose idea is we are implementing today and celebrating 26th of April every year as Intellectual Property Day. In fact, it begins on 23rd of April by celebrating World Book and Copyright Day. On that day, many great legendary creators like Shakespeare and Cervantes passed away, or many other people that same day is a birthday. So recognize their creative works and also the importance of books which they have written. World Book Copyright Day is celebrated, and the entire week is a World Intellectual Property Week, and it ends with 26th. Today is the World Intellectual Property Day. The theme of the day is intellectual property, IP, and SMEs, small scale enterprises, small and medium enterprises, and taking your ideas to market. So by encouraging these SMEs and startups to not only who are not only a creative entities, innovative entities, which may be creating patents, designs, trademarks, and copyright works, but they're also users. So it is important to promote these SMEs by giving robust right to them, which all our intellectual property right laws, any legislations in India, which are in harmony with not only the WTO's TRIPS agreement, and also various IP treaties which India is a member, like the Berne Convention or World WIPO Internet treaties like WCT and WPPT, and Paris Convention of Industrial Properties, which covers industrial property rights. Copyright in the digital environment, extending the protection of copyright digital environment, one of the steps taken in the norm setting, international norm setting in the WIPO, the standing committee, which called it diplomatic conference in 1996 to extend the rights of copyright to digital environment by creating two more treaties with the consensus of WIPO member states. One is WIPO Copyright Treaty, and second is WIPO Performers and Phonograms Treaty. These two treaties recognize the making available right digitally through internet networks, online networks from anywhere and anytime. So that required not only the making available these works digitally on various digital platforms, but also amending the existing definition of the communication to the public, because once a work is made available on the internet, it can be made available from anytime, anywhere, any place, and it can be streamed and it can be accessed also anytime, anywhere, any place. So such amendments have been done and special rights have been given. And also one more question came, how to protect, extending adequate remedies in case of any online piracy happens, unauthorized uploading and unauthorized distribution through online happens. So to address that, of course, technology, the information communication technology does give an opportunity to creators and right owners a platform that is the digital platform with online network, access to various people all over the world. The works, the creative works, not only access in their native country, all over the world, their works were made available. But that was accompanied with the problem of online piracy and unauthorized uploading these works, not taking license and uploading and making it freely available, which became a big problem for monetization of content of the authors and various creators, and also the right owners. So then technology came to address this illegal online uploading and illegal online distribution. So what is this technology? The encryption technology started being used, putting locks, digital locks on this content, and only authorized persons with login and password which works as a de-encryption key once they make online payment. So this practice started to continue the monetization process and also contain the online infringement and illegal online distribution in unauthorized manner without license. But there are people who are intelligent and they can hack these content and de-encrypting this content. Even access control encryption devices are put, or copy control encryption devices are put on the content. So both devices were hacked and content being downloaded illegally and distributed illegally and unauthorizedly, and unscrupulous persons uploading this everywhere. And people started thinking that whatever available on internet is in public domain and it's freely available. But the concept of public domain is totally different. A content enters public domain legally means it is out of the term of copyright, economic term of copyright in the Indian sense, that is life of the author, and 60 years for literary, dramatic, artistic work and musical works, and 60 years for the sound recording, and 60 years for cinematograph film. And this problem also extended to various software works and computer programs, which are treated as literary work in India. That's why the TRIPS flexibilities, Article 10 of the TRIPS says that the computer program or software is nothing but a literary work as per the definition of the literary work given in the Article 2 of the Berne Convention, which is that it's an original expression expressed in any other form. So the source code and object code of a computer program or software is expressed that expression is nothing but a literary form. That's why it can be treated as a copyrighted subject matter, or like some countries which extend patent protection, that is also possible as per the Article 27, which says that patents can be granted, shall be granted to any field of technology provided. So ICT is a technology, provided it has novelty, inventive step, and industrial application. So India, because of the various public interest benefits, India did not extend software patents. And as per the Patent Act, Indian Patent Act 1970, Section 3K, computer program per se is not a patentable subject matter. So it's not an invention, in fact. So a computer program can be protected in India as a literary work. Then question came, how to avoid the infringement, online infringement. Then, circumvention of technological protection measures, any digital locks or digital devices used by the author or content owner or a right owner on digital networks or online networks, making these works available. And if anybody hacks, knowingly does it illegal, so adequate remedies can be provided as per the Article 11 and 18 of WCT and WPPT. So India harmonized all these provisions in the Indian Copyright Act in 2012 amendments, and Section 35A and Section 35B have been introduced. And there is a concept of mens rea in criminal law. Similar thing has been introduced here. Anyone knowingly hacking and circumventing these technological protection measures introduced by creators, authors, and right owners will be liable for a fine and also 2 years infringement. Not only hacking these devices, after hacking and any removal of rights management information, like removing the title of the works, title of the name of the works, or the author's name, or publisher's name, or ISBN number, etc. All this copyright information, and trying to plagiarize this work and promoting and passing off that work as his own work. Infringement of copyright is addressed in Section 51 of the Act. Anyone trying to sell, trying to distribute a work, trying to make this available online, trying to rent these works, whether literary works, artistic works, or sound recording, musical works, cinematograph film, even software, without a permission, without a license, and it is infringement. And there are civil and criminal remedies. Civil remedies means district court may issue injunction, and you can get accounts of profit and damages. Anti-pillar orders can be issued. A raid can happen without any FIR and any summons, and entire infringing material can be sieged, including the machines used, devices used for making these pirated copies. And then criminal remedies fine from minimum 50,000 to maximum 2 lakhs, and minimum 6 months of imprisonment to 3 years of imprisonment. And then another important thing one should know, that if anyone in his laptop or a desktop and downloading illegal software to make the laptop and the desktop work, and the burden is on the person who is the owner of that laptop and desktop to prove that pirated software being used in that device is not for commercial purposes. Then only you can avoid minimum 7 days of imprisonment. Minimum 7 days. Court may extend it to any days. It can be minimum 6 months, or as based on the grievance of the right owner and the gravity of that infringement, piracy, it may vary. But despite you prove your innocence that you are using that pirated software on your laptop, desktop for your personal purposes, you can't avoid 50,000 fine. So 50,000 means you can buy a very good modern laptop. So why do you want to, get into such kind of trouble and end up in paying such a huge amount of fine? So I always request various institutions and bodies to have a committee which takes care of all the computers and laptops officially brought by them, that they are installed with only the legal software, but not illegal or pirated software. Similarly, individuals also should go for that, because it's a respect to the creation of intellectual property in that. There are exceptions, copyright exceptions for computer software also. You want to copy for your personal purposes into device. If such thing is allowed, that can be done. And re-engineering can be done. So you want to break open that software source code and object code and study how the software is made. And then you want to innovate and come out with a better functioning software, since your language is original and which is not copied from the original source code and object code, then it's not infringement, because you're going to create a new software with the new features and then new benefits to the user. So that is very, very important. So I've been talking about infringement. Again, I want to repeat that any infringement of copyright is regarded as an infringement once you have not taken any permission from the author, not taken a license, and illegally uploading or distributing or selling and monetizing it. Then what is plagiarism? Plagiarism is a kind of ethical construct. If infringement is a legal construct, as I told you, legislation, copyright legislation recognizes it is as a piracy, as an infringement, and there are civil remedies against that and criminal remedies against that, as I told you. Then what is plagiarism? Plagiarism, unlike a legal construct of infringement, it is ethical construct. It is in immoral activity. You are passing off others' work as your work. If iPhone is made by Apple company, Samsung taking that iPhone and putting its brand name Samsung and selling it. And despite that, you know that it's not a Samsung product. Samsung products are different, and they simply change the brand name and selling the iPhone 12, 13 with Samsung name. Similarly, if you cut and paste, copy and paste from other works, that is plagiarism. That is immoral, because by doing plagiarism, you are not only fooling the author, fooling the publisher, fooling the reader also. In infringement, what happened? Only the author and publisher getting a loss. Here, even because a reader knows that infringed copy, pirated copy. Here, even reader gets fooled, because when you do the copy pasting and you have such a big name in the educational institutions and education sector. If a person does this, a reader who is not exposed to that subject will obviously think that you have written that. But actually, you are passing off others' work, simply cutting and pasting. So this kind of plagiarism may be single source plagiarism. You may be cutting paste from one book, or multiple source plagiarism. You're cutting and pasting from various other similar subject matter, or sometimes you may be doing self-plagiarism. You may write a book, you may write an article, you can cut and paste in other book without referring it and giving citation of your own citation, your own reference, because again, you may be doing infringement there. Not only the plagiarism, because you, while publishing your article, publishing your book, you must have already transferred your copyright to some journal which published that article, or some publisher who published that book. So you may be thinking, I am the author, so I can copy and paste. No, you lost your rights because you already assigned your rights. So that's why you have to be very careful. So to not indulge in self-plagiarism. And there is a ghost plagiarism. That is, somebody have ghost writers. And when I registered for PhD on my private mail, I started getting various mails. So we have come to know that you are a registered PhD scholars. Tell us what is your proposal. Send a proposal, chapter-wise. What are your chapters, and we will write whether it is going to be empirical thesis and doctrinal thesis, and then we are going to do it for you in consultation with, and final product we'll be making for agreed amount. Look, this kind of thing happening. So finally, what happened? Student, the PhD scholar, who may be having issues with timelines. So he's getting his ready-made chapters and is pulling his supervisors and everyone. And maybe his entire PhD is made of such plagiarism. So one should be very, very careful. And many people think that software used to identify this kind of plagiarism software, various products are available. 15% is allowed, 20% is allowed, 30%, no such thing is allowed. Tell me which section, which subsection, or which provision of copyright law is allowing such plagiarism, infringement? No, it is a myth. You should not. And then many people think that I'm paraphrasing it, a sentence, and then I need not give citation or a reference. No, that is also wrong. And that is also plagiarism. You have to continue with your citation. You have to continue with referencing. Otherwise, it plagiarism, and then that should be recognized by everyone. You have to respect other people's work, and that should be the first and foremost thing when you are writing, and giving respect to others' expression. Even it may be a small phrase. That phrase may be getting repeated again and again. Entire a chapter, entire concept, entire idea promoted by the author in his article or a book based on that phrase. How can you steal that phrase, and then without giving reference, you say it's only a phrase? Just like in Constitution, we have the famous phrase introduced by Supreme Court in Keshavananda Bharati case, that is basic structure. That phrase is introduced by Supreme Court of India, the great judges who wrote the judgment. So you can't, without giving a reference, you can't own that phrase. I'm just giving you example. And then people think that quotation. So I paraphrase a quotation, that suffice? No, you have to still you paraphrase, and you may be a best English scholar, your written English may be good. Still, you are supposed to go ahead and give a citation and reference. And then come, so how much a quotation can be taken? So it should not be more than two lines. So exactly you are repeating it in inverted commas with citation and reference, even though you are converting into language. Many people cut and paste paragraphs to paragraph. They think that they're given citation and reference, that's enough. No, many times, I remember when I wrote a chapter for Coppinger and Coppinger's another book on moral right. In agreement, they clearly said that if you are taking any long quotation, you need to take permission from the publisher or author who are the right owner. It's very strict. If you are taking too much from a book and simply say that you are giving quotation, your citation and reference, that is suffice. No. Then question comes, now the technology is changing, and now the text data mining is happening, and artificial intelligence also being used and creation of works. Many people have doubt whether AI can be recognized as a copyright owner, because the machine learning, the deep learning, and various predictive, prescriptive analysis, which is going to, which these algorithms are going to do, because they are thinking. So I give you a simple example. Recently, Guardian newspaper come up with an op-ed of 500 words. A young intern working there collected material, documents on a particular subject and fed into the artificial intelligence algorithm computer. And then it did that text mining, and using that, this machine learning, deep learning algorithm wrote a 500-word article. It's a original article. Then you say that who will get a copyright? So obviously, that as person who has fed, what copyright law says, section 2, subsection A 6 says, person who is behind the computer is the author of this computer generated work. So it is simply a computer generated work. You can't ascribe copyright to that algorithm or artificial intelligence machine, because it is expressive. It can express only the information fed by you. It can't be like you are sitting in the canteen and sipping a cup of coffee. Suddenly you get an idea and start scribbling on that important topic, and then later you convert into your a paragraph in your article, or a paragraph in your PhD thesis, or a book you are writing. So unless until you feed, whatever photographs you feed, that's what AI collects. Whatever content or tables you feed, of course, it also creating a ready-made material and giving it to you, but based on what are information given to you. So that is the reason why, as a conventional and purist copyright person like me, we always say that copyright goes to only the person behind using such AI machine or computer. All computer generated works based on AI or software belongs to person. Who is the person? Person may be a natural person like you and me, or a legal person like Alliance University. If Dr. Kiran Gardner has been given a task of prepare an annual report of the university law college, when she prepares, she has been paid to do that. She is on contract of service. Obviously, as a writer, she is the first owner of copyright, but the entire report belongs to the Alliance Law College, and copyright owner is Alliance Law College as a, and then so the legal personality as a legal personality. So you should know this. Recently, David Slater, a wildlife photographer roaming in Indonesian forest, left his camera on a tripod, and a macaque monkey named Naruto came and took a photo selfie, and then controversy started when David Slater started monetizing that beautiful monkey selfie. Obviously, the PETA, the people for ethical treatment of animals, they took up this cause. They said that monkey is the author, because person who takes the photo is the author, but monkey is not a person. Still, they're animal rights activists. They went to court in the US, and despite David Slater won in the initial courts, in the first court and second court, the matter was going to Supreme Court. And then somehow he thought, why wasting money on this thing? And then he said, 25 or 30% amount of my commercial revenues over these photographs will be spent for animal welfare. Then that trouble ended. So here one should recognize that person is the first copyright owner, and that is a natural person, not a monkey, not AI. That there may be a business model developing how this has to be addressed when machine belongs to whom or AI belongs to whom. That's a different thing. Due to paucity of time, I won't be covering things. What I say again and again, that whatever available in the public domain is not copyright free material. So please respect copyright and take permission, give citation, and promote these ideas, and encourage people to create more, and also respect copyright. That's what I would like to say on this day of World Intellectual Property Day. And thanks my friend and respected Professor Kiran Gardner, Dean Law College and Pro-Vice Chancellor of Alliance University, inviting me to share my thoughts. And namaskar, Jai Hind. I request all of you to wear mask and maintain social distance, and protect your families and your friends. Only you can protect from spreading this pandemic, and stay safe and take care. Thank you.
Thank you.
Thank you, Mr. Raghavendra, for an insightful explanation about copyright and
I
its
take
protection.
permission because I have to join some other meeting. I'll be happy if you give me permission to leave the event.
Sure, sir.
Yeah, thank you. Thanks a lot.
Thanks a lot.
Thank you, Mr. Raghavendra. We now have Ms. Bindu Sharma, who will be addressing the gathering on the topic Patent to Boost Innovations. Ms. Bindu Sharma is an IP attorney with extensive experience in IP laws across a range of technologies and industries in India and abroad. She enjoys working with innovative organizations and inventors and guides them in protecting their intellectual property in the most effective manner. She has extensive experience as a patent lawyer, appearing in appellate board and high courts in patent infringement cases. She has written several articles, authored books, and has been a speaker in more than 100 national and international conferences, academic institutions, and corporates. She was also recently recognized as one of the top 100 women in law by WIPF. Ms. Bindu received her law degree from Bangalore University and postgraduate degree from University of Horticulture and Forestry, Himachal Pradesh, with distinction. She is a registered patent agent with the Indian Patent Office and is also enrolled as an advocate with the Karnataka State Bar Council and Bar Council of India. And she received a postgraduate diploma in IPR from National Law School of India, University, Bangalore, and completed general course in intellectual property rights from World Intellectual Property Organization Worldwide Academy. Ms. Bindu Sharma is the founder of Origin IP. Under her guidance, Origin has achieved a tremendous growth and has established a substantial client base. I now request Ms. Bindu to proceed with the session.
Hi, good afternoon, everyone. Before I start, just want to ensure screen is visible and I'm audible.
Yes, ma'am, it is visible.
Okay,
and you're
fine.
audible.
Yeah, perfect. First of all, happy International IP Day to all of you. And I thank Alliance University, especially Dr. Kiran, to invite me today for this session. So I will just briefly take you through, patents is a very commonly used word these days, especially after the Startup India initiative, took off in the country, and lots of startups and lots of innovations are now coming up, and we need to understand how patents can boost innovation, how does patent filing helps industry to take off. And this crowd, I guess, is like law students, so I'll probably take you through more into um, uh, statutory provisions with respect to patent law. And at the end, we will discuss career prospects for advocates in IPR. I have made a specific video also on this, because there is always a clash, because advocates cannot write patent agent examination, and patent agents, they are not lawyers. So I'll try to resolve it at the end of the session. And thank you so much for all of you to be here today. I'll start with this statement of Albert Einstein. He said, uh, uh, one second, I'm just trying to, just give me a minute. Okay, fine. Okay, so it says Albert Einstein said the true sign of intelligence is knowledge. So knowledge is there, like, and imagination is much more important than knowledge. The reason is that knowledge can only take you from A to B, but but imagination can take you anywhere. So all inventions that have happened in the history, they are the indication that imagination is more important than the knowledge. There are several examples, breakthrough innovations in the history, and and they prove that imagination is much more important than the knowledge. In simple words, intellectual property rights refer to creation of mind, and creation of mind can be in any form. It can be invention, it could be in the form of a book, it could be design of a new product, or it could even be your innovative logo or name of the business that we call as trademark. So intellectual property is creation of mind, and this creation of mind you can own only if it is registered. The way you buy your house and it needs registration, your land needs registration, and in the similar fashion, intellectual property, if it is created, it has value and it fulfills the statutory conditions, then it can be registered. But unlike your house or your land, intellectual property gets registration only for a particular period of time, and it is also subject to certain conditions. So I'll explain you what are these conditions. And each form of intellectual property has to fulfill certain conditions in order to get registered. Patent is one of the most talked about form of intellectual property, and there are various reasons why patents are important. So patents are granted for the inventions. So invention could be either a product or it could be a process. In the picture, you see that it is motorized exoskeleton. So in the left side, you see the drawings that are shown with certain numbering. So this is the kind of drawings that are submitted in patent specification, and the real-time picture of the product is on the right side. So when we write a patent document, then we cannot submit the photographs. It has to be line drawings the way it has been given in the picture on the left side. And patent rights are not perpetual. Patent rights are only for 20 years from the date of filing, not from date of grant. It is from date of filing. 20 years term is given, and after 20 years expire, anyone in the industry can use the invention without permission of the patent holder. So, but as long as patent is in force, permission of patent holder is required in order to use the patent. Now you see in the COVID time, there are lots of innovations coming up. People are looking for out licensing the invention, commercialize the invention, because now there is a great need of inventions related to ventilators, oxygen, and different kinds of masks. And out of all the innovations, probably ventilator and oxygen, they are the most important devices required right now. Patent rights are territorial. That means that Indian patent is valid only in India, and if you want a US patent, then the patent has to be filed separately in the US. So patent rights are completely based on the country you are in. And if you have to, have rights in multiple countries, then there are ways to file your application in multiple countries. But yeah, the application has to be filed separately in all those countries. Copyright, I think you have already learned more in detail in the previous session. So copyright is for the work of authorship. There are some five, six classes in copyright: literary, artistic, cinematographic, musical. And the copyright has to fit into these classes only. Because when you file application for copyright, you have to specify in how many classes you are going to file your copyright in. And suppose your work falls into more than one class, like literary and artistic, then you have to file two application, and your fees also gets doubled. So that is the reason that copyright classes, they have been specified very, very clearly in the act. Trademark, I think, is one of the most common and popular form of intellectual property, and you all understand trademark very well. There are lots of trademarks around, and if you look around, you will be at least, be able to find 50 plus trademarks in your house itself. It may be more than that. So trademark is brand name, logo, and tagline. So these three comprise a trademark. So trademark may also be confined to a different font size. It may be confined to a different style of writing, color combination, and some of the trademarks, they have a piece of artistic works also in them. So all collectively we call it as trademark. And if I take you through some of the trademarks, can anyone tell me from audience what is meaning of Paytm? Anyone from audience who can tell me what is the meaning of Paytm? You can as well type in the chat box. What does Paytm stand for? Or you can unmute and say. I hope I'm audible. Yes or no?
Yes, ma'am, you're audible.
Okay, so what does Paytm stand for? Anyone? Paytm stands for...
Is it paid to me?
No, it's pay through mobile.
Okay.
Okay. And this color combination is unique to Paytm, and Paytm was having a big time litigation with PayPal, because both of them, they are into financial services. Color combination is same, and both trademarks, they start with P-A-Y. Then Nestle, started by Henry Nestle in 1868, and hence the name Nestle. Then we have Baskin Robbins. So if you look in the logo, look inside the logo, then you see the 31 number. This indicates that Baskin Robbins, they have flavors for every day of the month. Biba is an apparel brand. Women in Punjabi is the meaning of the word Biba, and this motif indicates peacock feather. Then we have Amazon, very popular trademark. So this arrow indicates that Amazon has all stuff from A to Z, which is true. Picasa is home of all pictures, and you see just in the center of the logo, you can see the image of a home. So that's what Picasa is. The word P-I-C-A refers to case. FedEx is one of the most innovative trademarks, and if you see the space between E and X, in E and between E and X, there is a arrow that gets formed, and FedEx is known for smart use of negative space. And FedEx has got various awards for clever use of negative space. Then is the brand Havells electrical appliances, and Havel, the word has come from the person Haveli Ram Gandhi who started this company. MDH is Mahashi Andi Hatti, so MDH is a abbreviation. Now comes the design. Design is a kind of intellectual property wherein the protection is given only to the aesthetic look and feel of the product. So design has nothing to do with functionality of the product, but the design refers only to aesthetic look and feel of the product. So in first picture, you see that, toothpaste, probably the product is same, but just changing the head of toothpaste, it makes it much more attractive, especially for the kids. And second image here is the bike, and the design here is very innovative. And the third picture is a kind of chair. So design is a kind of a right which is granted only to the innovative and the products that are aesthetically appealing and they are beautiful. Geographical indication is again a very interesting form of intellectual property, and geographical indication refers to specialty of a place. So can you give me some example of geographical indication? Whichever state you are from, just give me one example of specialty of your state. I'll start with the Karnataka. So Mysore silk is geographical indication of Karnataka. Can you give me any other name?
I am from
Bengali Rasgulla. Yeah.
I am from Tripura, so Queen Pineapple of Tripura.
Very good. That's correct. So Darjeeling tea, Bengali Rasgulla, Arvind, Priyanka says Darjeeling tea, absolutely correct. Any more examples?
Nagpur orange.
Kanchipuram saris, Bhavya Sharma. That's right. Odisha Rasgulla, that's Gayatri, perfectly all right. Warangal Daris, that's correct. Okay, so these are the geographical indications and very interesting form of intellectual property. Let's take some examples. Pashmina wool is one example of geographical indication. Since I am from Bangalore, so I have taken most of the examples from Karnataka. And Karnataka also is a state with maximum number of geographical indications registered in its name. So government of Karnataka has taken good initiatives, and their team is visiting from village to village, identifying the specialty of the places and helping the artisans to register their geographical indications. And I feel other states also need to put more efforts to register their GIs. Then Mysore silk, this is Bidri work from Karnataka. So this work is done with silver, and this is a very, very beautiful work. Then we have chicken from Lucknow. This is a particular pattern that is put on the shawls and caps in Himachal Pradesh. Madhubani painting is another example. This is sandalwood oil, jasmine from Karnataka, bitter leaf from Karnataka. If you have happened to be in Bangalore and travel to Mysore anytime, you will see lots of shops of wooden toys. They come in Chanpatna, so these are also geographical indications. This elaichi, rose onion, Mysore sandal soap, these all are geographical indications that are registered in the name of Karnataka. Internationally, if we see, champagne is registered, Scotch whiskey, Havana cigar, Colombian coffee, these all are registered geographical indications. And geographical indication, if it is registered, it adds lots of value, and the producers, they can really, be benefited by registered geographical indication. Now coming to traditional knowledge. So traditional knowledge, we all know that it is the kind of knowledge that gets accumulated from generation to generation. And traditional knowledge is never registered. So this makes traditional knowledge very different from other forms of IP. So traditional knowledge is not registered, but traditional knowledge is protected only by documentation. So if in India we are using haldi and we are using haldi for wound healing, then we cannot register it as traditional knowledge of India. but we can only document and publish it as a traditional knowledge so that others do not claim any patent rights or any other kind of rights over it. So traditional knowledge is never registered. There are some chats, in the chat box. Puran Poli, Kolhapuri Chappal, some of you have given examples of geographical indication. Belgavi Kunda is registered. Yeah, that's right. Mysore Park Suite, Mysore Park is not yet registered. Okay, Mysore Park is actually having lots of issues, so not yet registered. There is a tie between Tamil Nadu and Karnataka, the way we had tie for Rasgulla between Odisha and Bengal. Some examples of traditional knowledge: folk songs, use of turmeric for wound healing, neem, usage of neem as an antifungal agent, folk dances. So folk dances, folk songs, and similarly, there are lots of traditional knowledge in the community with respect to making extracts of different herbs to cure diseases. So these all are traditional knowledges, and they need to be protected by documenting and publishing. So CSIR in India is maintaining traditional knowledge digital library, wherein we document all traditional knowledge that we have and we publish. So if there is any patent,
Bindu ma'am, you need to unmute yourself.
yeah, there was some issue with the internet. Okay.
Yeah.
So trade secret is a kind of intellectual property wherein the IP is a secret, so it is not known to the world. So every industry has one or the other trade secret, and food industry specifically is full of trade secrets. McDonald's aloo tikki, then you have Coca-Cola recipe and KFC chicken, the mixture of herbs. It is like trade secret. So trade secret is protected only by maintaining the secrecy of it. So the moment your trade secret is out in the market, it is no more a trade secret, and it loses its value also. So again, trade secret is not registered. Like, traditional knowledge trade secret is also not registered. Now, coming to patents, the word patent means to disclose. So whenever patent is filed, there is some disclosure that is done in the process of documentation and submission of application. And in return, government grants specific rights for a particular period of time. So is the screen visible?
No, ma'am, it's not visible.
Okay, I'll again share my slide. Wait a minute. I'll just share the screen. Wait a minute. I hope it's fine now.
Yes, ma'am.
Okay. Okay. So patent is a grant by the government and which is given to novel, non-obvious and industrially useful inventions. Term of a patent is 20 years and rights are completely country-wise, territorial. I'll explain these things to you more in detail. Now, looking at history of patents, so probably in ancient Greece, it started wherein there were some rights given to the chef and there was permission required from the chef in order to replicate the dish. So this probably was the first kind of IP rights granted in one or the other form. Then we had letter patents in UK. So letter patents was like whatever innovation you have, you will put on the in the form of letter and submit it to the Queen, and Queen will review it and grant specific rights for a particular period of time. Then there is some evidence of having patent rights in Italy as well. So, but when we look at India, the system of patents, it started quite late in India. We had a Patent Act in 1856, then 1857. Then after independence, we had first patent statute in the year of 1970, and we follow this act even today, Indian Patents Act 1970, even though with lots of amendments, but this is the reference statute for us with respect to the patents in the country. Now, why to file for a patent? There are various reasons to file for a patent. They protect innovations. So this is one of the reasons to file for a patent. And once the companies, they have patents, they can really have competitive edge in the market. Like you have new phones on Apple, your iPhone, and if Apple has patent on it, so Apple can prevent everyone else to replicate that particular feature. So this advantage gives competitive edge in the market. Patents are good for branding of the organization. Now, if you see that, patent office publishes annual report every year and they list out the highest patent filing companies and academic institutions. So like MIT is always on the top. So it gives kind of branding that you can always say that I have 5 patents, I have 6 patents. And many companies, they use patents mainly for branding of the organization. So if patent is commercialized, then it can be a good source of revenue. And for the startups, investment becomes very easy when they have patent, and with patent it becomes easy to talk about the invention, because without having a patent, if you disclose your idea to somebody, it feels like, if idea is misappropriated, you are nowhere. But with patent, you are kind of, you can disclose about your invention without much hesitation. So there are 3 conditions required to get a patent. First of all, invention has to be new. Second is it has to be non-obvious. And third condition is it has to be industrially useful. So first condition is that there should not be any public disclosure. There should not be any documentation. There should not be any patent about the invention in public domain. So if there is no disclosure about the invention in a public domain, you can say that invention is novel. And it is very important to know that, inventor's own publication also can prevent him from getting a patent. So there was this case of Mento versus Mentmore. In this case, they made improved nib for ballpoint pen, and and they started manufacturing the product. They published it, and after the product became very famous, they thought of patenting it, but their patent was rejected by the examiner, saying that the invention is not novel because there is a public disclosure about the invention. So inventor's own publication can prevent obtaining a patent. So never publish or make public disclosure before filing for a patent application. So in case one wants to make a publication, then it is highly desired that patent application is filed first and then later on publication is made. Now, you cannot just join 2 existing devices and say that I have invented something new. Now, you combine a glass and your cell phone. So if you combine glass and cell phone, it may be a new product and you may not have any such product existing in the market. But this does not make it a patentable product because glass is known and your cell phone is known. You're just combining two existing devices. So your product is obvious. But in order to get a patent, your product has to be non-obvious in nature. So just novelty is not enough to get a patent. If you see this example, this is a very beautiful example. Indian women, they have been found to have deficiency of iodine. So what this product does is, this bindi has a layer of iodine. So once a lady wears this bindi for 24 hours, the requirement of iodine is fulfilled. So this again is, it is a very beautiful example of simple and innovative product. The third requirement to get a patent is that there has to be industrial application of the invention. If there is no industrial application, then patent may be denied. So most of the inventions, they fulfill the criteria of industrial applicability. But sometimes some inventions, they get stuck. So there was one case I can refer here is John Lahiri Khan. He came up with the novel concept of making friends. So now making friends is not an invention, if you really ask me. So this application was rejected on the basis that concept of making friends fails to have industrial application as a fulfilling condition. So patent was denied for this particular case. I'll show you this video. So, we all have ice trays in the fridge, but this product is very beautiful. And this is not just ice tray, but also it can be used as, what is it called? Ice box. Yeah, ice box. It can be used as ice box also. So just watch this video. Okay, I hope you like this product. So this product, again, if patent has to be filed, it has to fulfill the three conditions of patentability, that is novelty, non-obviousness, and industrially useful the product has to be. Now, if you look at most powerful inventions in the world, then wheel probably comes on the top, the oldest and most powerful inventions, followed by nail, compass, electricity, internet. I don't need to explain how powerful internet is. You realize only when you don't have Wi-Fi connection for 1 hour. Then can anyone identify these inventors? Anyone? Can you tell me who are these inventors and what they are doing?
Wright brothers.
Absolutely right. Absolutely right. Okay, then steam engine, printing press. In the last session, you learned about copyright law. So copyright law was never important till the time printing technology was invented. So that's why printing press is supposed to be one of the most powerful inventions in the world. Electric bulb. Who was inventor of electric bulb? Who invented electric bulb?
Edison.
That's right. Good. Then this is one of the products, of NASA. NASA maintains a very beautiful site to showcase the inventions that are available for licensing. So this product is called as Finder, and this product was widely used during earthquake of Nepal. So this product can sense the heartbeat of a person from a distance. So using this product, they could save lots of lives. So this is a very useful product that NASA had developed. Then who was inventor of telephone, first telephone?
Alexander Graham Bell.
Yeah, that's right. So in the system of patents, it's very important that as soon as you have new idea, you have to file your application, because patents are granted on first come first serve basis. So if there is any delay, or if you fail to file for a patent in time and somebody else goes and files, then you lose a chance. Okay, so first come first serve basis, the patents are granted. So it's very important to file for a patent as early as possible. So this was a very famous legal battle. In 1870, Elisha Gray and Alexander Graham Bell, both of them, they designed the telephone. And somehow Alexander Graham Bell reached patent office earlier. And now we know that Graham Bell is inventor of telephone. And if you file patent application in India, you know how specifically they give you date and time of filing. They will say 26th April, 1 o'clock, 30 minutes, 40 seconds. So that is called as the date of filing or priority date. So first filing is very important, and that should be done without any kind of delay. As an inventor, precautions that are required to be taken is like documentation is very, very important for patent filing process, because you have to disclose the invention much in detail. And in the organizations, right, policies and processes have to be defined, and strict confidentiality of the work has to be maintained, so that novelty of the invention is intact at least till the time application is filed. Now, as per Patent Act, true and first inventor has to file a patent application. But at times what happens that, you know, if the student is working in Alliance University, then since the student is using resources of Alliance University, working in the projects of Alliance University, so student would be required to assign the rights to the university, so that, you know, the university files for a patent, and name of the student remains in the patent application as true and first inventor. How much time do I have? It's 1:43 right now.
Ma'am, you have time till 2:30.
Okay, I have time. Oh, fine. Okay. So this was the first patent that was granted by Indian Patent Office, a pankha pulling machine. So if you have seen this machine in some old movies, you will see that, you know, there is a hall and there is a piece of cloth which, in the center, and on either side the person is sitting and pulling the rope, so that the cloth serves purpose of a fan. So this was the first patent that was granted by Indian Patent Office on pankha pulling machine. So you see the kind of drawings that were submitted. These are original drawings of this patent. So this kind of drawing can be submitted even today in patent office, and it could be either the line drawings or it could be hand drawn drawings, and the name of patent agent or the inventor has to come on the drawings. And in India, we can submit a patent application either in Hindi or English. So no other regional language is accepted. And now, since the filing is online, so you don't have to really submit the hard copies of the document at the time of filing. Later on, definitely you have to submit the original signed the documents. And there is a limit of 10 claims and 30 pages in a patent specification. And once you cross 30 pages or 10 claims, then there is extra fees that is required to be paid. And the receipt of filing is generated as soon as application is filed. And we have 4 patent offices in India, that is Delhi, Mumbai, Kolkata, and Chennai. So before starting the research, documentation of invention has to be done. Novelty assessment has to be done. And after one is sure about novelty of the invention, then Indian patent application should be filed first, followed by foreign filing if at all it is required. So filing Indian application is almost mandatory according to Section 39 of Indian Patents Act in order to ensure national defense and security. Whatever invention you are going to file for as a patent, you have to submit your document in India first, and then any kind of foreign filing can be done. If inventor is not wanting to file in India, then foreign filing permission has to be obtained from Indian Patent Office, but direct foreign filing cannot be done in India. Now, when a patent application is to be filed, novel elements of the invention, they have to come up very clearly. And then the inventor should have a problem statement in the patent application, that what kind of problem he is trying to solve and the way solution works. Now, in the image on the left side, if you see, this lady is drinking water. So what she is holding in her hand is a kind of pipe with multiple layers of filters. So any water she drinks from this through this pipe becomes a drinkable water. So this invention, if you see technically, is very important as far as developing countries are concerned. So do you feel it is a patentable invention? So it is multi-layered filter. You drink any water through this pipe and it becomes a drinkable water. Do you think it is a patentable invention? You can put in the chat box. You can put in chat box whether you feel this invention is patentable or not. Pooja says no. Okay. Arvind says no, non-obvious. Priyanka, yes. Sakshi, yes. Deshmukh, yes. Okay, so see, when we take decision on whether it can be patented or not, first of all, we have to see, is it novel? If there is any document already available, then patent may not be granted. Assume it is novel. Then is it obvious or non-obvious? So obvious and non-obvious is a statement that may vary from person to person. I may find it very fascinating, but you may not find it very fascinating. Okay, so obviousness is always a bigger question mark. And that's how the analysis of the invention is done, and compared to prior art comparison is done, and then you arrive at a decision whether you should file for a patent or not. But most of you have said that this looks like a patentable invention. Now, very often question is asked, can idea be patented? So answer is yes and no. So idea per se is not patentable. So I cannot just file for a patent for anything that is not executable. It should be executable. But yes, if it is executable, I have experimental data, I can always file, patent application with idea, and later on I can submit the complete details. So filing for a patent with idea as a provisional application is something that is desired, and later on you have to submit the complete application. But just idea which cannot be executed, if it is hypothetical idea, then you may not be granted a patent. But yeah, nobody can stop you from filing. You prepare a document, submit it, pay fees, and receipt is generated. So nobody can stop you from filing, but it may not be granted later on. Since patents are granted to the inventions that fulfill three conditions: novelty, non-obviousness, and industrial use. If these three conditions are there and invention fulfills these three criteria, there is no reason for examiner to refuse patents. So sometimes very funny patents they get granted. I'll give you some examples. So this is a granted patent, and if you have pets in the house, then this is a extension of bed wherein the pet can sleep. So this I found is a very funny patent. So this is a granted patent, and you see the kind of drawings that are getting submitted with the patent. Now you do lots of good work in life, and people don't appreciate. So this is probably the right device for you. So you can put this device on your shoulder, just pull the string and say, well done. So this is to boost your spirits. Okay, so this is self-congratulatory apparatus. Having a stimulated human hand carried. So this is the kind of language that is used in patent specification, usually very complex. People find it very complex, but I think as advocates, future as advocates, you will appreciate this language. So it's very twisty, and making sense out of the patent specification becomes, it's more of interpretation at times. For people with big mustache, it is mustache guard, granted in 1876. I don't know whether this product came in the market and somebody used it, but it is, according to me, it is a funny patent. If you have pets with long ears, then this probably is a device to manage ears of your pet. If you are struggling to lose weight, then you need to buy this anti-eating mask. Whenever you are hungry, you put this mask and lock it. Can you see the lock? So you can lock it. And once your desire to eat food has gone, then you can remove the mask. And this is called as anti-eating mask. This is a very funny patent. Then greenhouse helmet. So if you're feeling like, if you feel hot while wearing the helmet, then you have this new helmet wherein there is a layer to grow plants, and these plants give you a constant supply of oxygen. So this is called as greenhouse helmet. Then this is my favorite invention. This is snake collar. So if you have snake as a pet in your house and you want to take your snake for morning walk, then you need to put this collar around neck of your snake, and you can safely take your snake for morning walk. So this is one of my favorite patents. I always give this example. Then this again is a good one, diaper for the bird. So if you have bird in your house and they spoil the area around, then bird diaper is something that you need to make your bird wear. And surprisingly, this product is so popular that many companies, many brands, many designs you find, if you check on the net, bird diaper, you find many companies are manufacturing, and it's available in various kinds of designs. So on the left side, you see this is a patent drawing, and on the right side, you see this is the actual product. There is a list of inventions that are not patentable in India. So this is important to go through. Funny inventions are not patentable. Inventions that are injurious for human, animal, plant life, health, environment, they are not patentable. I cannot patent a method to pollute lakes, a method to create water pollution, a method to kill people in masses. So all these things are not patentable in India. Then just a discovery of scientific principle like E is equal to mc squared, just the abstract theory is not patentable, but yeah, application of theory to build a product can be patented. So new use of same substance cannot be patented. So this is section 3D, and you must read about section 3D. This is one of the most controversial sections of Indian Patents Acts, and it has been objected in various national and international forums. So please read about Novartis case and section 3D. So this says that new form of same substance cannot be patented till the time the new substance has better efficacy compared to the original compound. So if I have to explain it to you with help of a very simple example, I'll take example of water. Water is known. Now, if water is known, ice and steam cannot be patented till the time steam and ice are proved to have better efficacy compared to water, because steam, ice, and water, chemically, they are the same thing. Okay. Then admixtures are not patentable. You cannot just mix two things working independently and try to patent that admixture. Now, arrangement and rearrangement of known devices, like in this picture, you see that chair is known, umbrella is known. You're just putting these two things together. So this kind of product cannot be patented because it is combination of two known products. So in order to get a patent, you need to have something extra, some additional innovation level in the invention. Most of the methods of agriculture, horticulture, computer programs, they are not patentable. So computer program can be patentable only if there is a hardware component to it. And similarly, mathematical method, business method, algorithms, they are not patentable. And all over the world now, there have been question marks on patentability of computer programs, but end of the day, computer program per se is not patentable till the time it has a hardware component. Plants and animals cannot be patented. You cannot patent a dog, cat, or a plant. Similarly, literary, dramatic, musical, artistic work cannot be patented. They can better be protected under copyright. Presentation of information, the way I'm presenting or traditional knowledge of a country cannot be patented. Then we have another section saying that anything related to atomic energy is not patentable. The moment you have atomic energy in your mention of atomic energy in your patent specification, they may seal your patent. This is called as secrecy directions. They may imply secrecy directions on the patents, and they may patent office may refuse to examine the patent. So anything related to atomic energy is not patentable, but yeah, they give you opportunity to prove that it is not injurious for national defense and security, and then patent may be granted. Briefly taking you through the process of registration of a patent in India. So first of all, you have to file your application. So as I told you that filing is completely online nowadays. So you can prepare your document and file application in India. And after within 12 months from Indian filing, if required, foreign filing may be done. Foreign filing purely depends upon the preferences and choice of the inventor. Not everybody goes for foreign filing. Then in India, after filing, the application gets published on the Patent Office website. You can log into Indian Patent Office website and see every Friday they publish the applications, and on the same site, Indian Patent Office, same site, will see there is a trademark and geographical indication also, and you can get any kind of data on trademarks or geographical indications as well. After publication, the application is taken for examination, wherein the examiner examines the application. If he has any objections, he will ask you to fix the objections. There may be a need of one hearing, and after that patent is granted. And as in other forms of IPs, after grant, renewal has to be paid periodically in order to keep the patent in force. So this is very briefly the process of patent filing. So here I will mention that if you are not a graduate in science, you are not eligible to write patent agent examination. But as an advocate, you can very well fit into the role of handling the patent oppositions or patent revocations and litigations at later point of time. But in order to have in order to handle oppositions also, you will need support from I will say that you need some scientific support to understand the invention, because the way technology is getting complicated, you need to understand the invention very well before you handle opposition or revocation of the patents. And I will explain you the tasks you can undertake in companies as advocate if you want to pursue your career in intellectual property rights. Now, infringement is a very big subject. So in simple words, violation of rights of a patent holder is called as patent infringement. You see lots of cases, cases or litigations happening in the pharmaceutical industries, and then most of them, they come from telecommunications. Samsung infringed Apple's patents, and Apple infringed somebody else's patents, and that's how lots of litigations are happening in the industry today. So in simple words, violation of rights of a patentee is called as patent infringement. So this patent infringement can be avoided if certain due diligence or specific searches are performed before a new product is launched in the market. But otherwise, companies can get into the big disputes if these things are not taken care of in the beginning. Now, patent rights are negative in nature. So if patent is granted, the patent holder only gets right to prevent others from making, using, selling, offering for sale, and importing the patented invention in the territory of India. Now, I'll just give you one, suppose one has Indian patent. Suppose you have Indian patent. So what this means is that in India, you can prevent everyone else from making, using, selling, offering for sale, and importing. That means if you have an Indian patent, you can prevent third parties from importing the product in the territory of India. So these, in nutshell, are the rights of patent holder. And violation of these rights is called as infringement. Maybe we'll take a small case study here. This is one of the famous case studies, Philips versus Anand and Futuristics. Now, Anand Electronics and Futuristic Concepts, these two companies, they were using a technology, digital transmission system technologies, to manufacture VCDs. And they had a business in Delhi, but they did not know that Philips had a patent on this particular technology. So without doing any kind of due diligence, they started manufacturing the product. Later got to know that Philips had a patent for this particular technology. So Philips then pulled them in the court, and then Delhi High Court ordered these two Indian companies to stop manufacturing the VCDs that infringed Philips digital transmission system. So this due diligence has to be done in advance by the companies. Otherwise, this could be a very dangerous situation for any company, that after manufacturing, they have to stop, using or manufacturing the product. Now, when you buy a house, you know approximate value of the house. The apartment I live in, I know what is market rate for this invention, for my house. If there is a property in MG Road, I know the value, approximate value in terms of area, in terms of the facilities. So similarly, if you have a patent, you must know value of it. So I like the statement of Thomas Alva Edison. He said, "Anything that would not sell, I do not want to invent. The sale is proof of utility, and utility is success." So if you do not know value of your technology, you will never be able to sell it at right price. So knowing the value of technology is extremely important, and inventors or the companies, they should do this exercise so that they can find right buyers for their technology and sell it at right price. So there are certain criterias, when it comes to evaluation of technology. So when inventors or academic institutions, they have to sell their patents. So first thing is they should evaluate how valuable their technology is. And then based on that particular value, they can find the right buyers and then commercialize the technology. We'll have last 5 to 7 minutes for discussion. So there are 3 ways using which technology can be brought to the market. Patent holder can always license technology to somebody else. Suppose there is invention related to cosmetic product, then tying up with the company that is already into this business, like L'Oreal or Lakme, is a good idea. So what a patent holder can do is, patent holder can license the technology to L'Oreal or Lakme, so that L'Oreal or Lakme, with their manufacturing capacity, can manufacture the product and in return pay some royalty to the patent holder. So licensing is one of the most popularly used mode of commercialization of the invention. The second mode of making money from a patent is you sell off your patent. So if a company is interested, you say that I don't care about anything, you just take my patent. So there is a fees involved, and you can always, patent holder can always sell off the patent. There may be a possibility of joint venture, wherein an industry and patent holder, they come together and they start a new line of business. So these 3 are the commonly used modes of technology monetization. Now, in order to determine value of the technology, I thought this is COVID time, and COVID vaccine is one of the ways to explain you better. So now you see there is huge population across the globe fighting against COVID-19. Now, company X comes up with vaccine. So is it a valuable technology? COVID-19 vaccine, is it a valuable technology or product? If we have to evaluate COVID-19 vaccine, how do we go about it? So before that, is it a valuable technology as of today? Yes, all answers are yes. Deshmukh, yes. Bhavya Sharma, yes. Aishwarya, yes. Sharad, yes. Okay, it's a valuable technology. Now, when we evaluate a technology, first of all, we find out how different the technology is compared to the existing products or technologies in the market. If it is just a mere replication or some improvement, then it is not a valuable technology. So nobody will be interested in investing money for such technologies. So if it is different from existing technologies, it is a valuable technology. Okay. So otherwise, I mean, typically prior art search is performed to identify the existing products or technologies, patents, publications in the market. Compared to existing knowledge, you compare how good the patent is, and that becomes one parameter to evaluate a patent. So if it is very different from prior art, then it is valuable. If it is not very different from prior art, it is not very valuable technology. Market research has to be done. Now, there are technologies, extremely good technologies, but market is not ready for those technologies. COVID vaccine, if it had come 5 years ago, it was not a valuable technology, right? It has come now, so it becomes a valuable technology. Was mask a valuable technology 5 years ago? Was mask design a valuable technology 5 years ago? No. Similarly, oxygen cylinders, concentrate of oxygen, they were not valuable 5 years ago because there was no need. So now these things are very important. So in order to evaluate a technology, market analysis has to be done to find out, is market ready for this technology? What is going to be the market size? Now, if you see for COVID vaccine, market size is phenomenal. Each and every person probably in the population has to get vaccine today or tomorrow. And as you know, as of today, you take population of the world, but every the newborns, they will also start adding in the list. So market is huge. But do you think this demand is going to remain forever? COVID vaccine demand, is it going to remain forever? So shelf life of this technology is very short. Am I right? Shelf life of this technology is very right. Demand for sanitizer, mask, oxygen concentrate, ventilator, is it going to remain forever? No, it's not going to remain forever. So when valuation of technology has to be done, we have to see how long the demand is going to remain. Okay. I'll give you one example. What do you feel when was touchscreen invented? You will be surprised to know that touchscreen was invented in 1960, but there was no market for it. So this technology became valuable only after 50 years from the date of the first invention. So touch screen was invented in 1960, but this technology was implemented in 2010 probably. 2010 probably first touchscreen phone came. So even if technology is good, but if market is not ready, it's not a valuable technology. Okay. Technical feasibility has to be there. Your invention has to work. Okay. So if you have a great invention, if you have a portable ventilator, but it is a very successful product, you say it is very good, easy to use, eco-friendly, cost-effective, you give me 10 parameters, I will not buy till the time I see a prototype or you run pilot project for me. Because I want, before paying for technology, I as a buyer want to see whether it's working or not. If it is not working, I'm not interested. How good your product is, I don't really care about it. So for the patent holder, it's very important to showcase the technical feasibility of the invention which he's trying to sell. Then clearance search has to be performed to ensure that if I've invented a ventilator, I have to have my due diligence done to ensure that, if a company manufactures my ventilator, they should not get into any legal dispute. So it should be free of any allegation or it should not overlap with any IP rights of third parties. And I should be like free of any legal complication, because it's not a very good area to be in, and companies, they don't want to unnecessarily get into any kind of legal disputes. Then after all these things are done, then you must find a buyer. So if I have a product like ventilator, I should probably list out the companies that are into manufacturing of ventilators, contact them, convince them about my new product, my new technology. And if they are interested in buying, then the final negotiations happen. Then execution of agreement, which is called as technology transfer agreement or licensing agreement, is executed between two parties. There are lots of clauses in execution of such agreements. Maybe you can go through this. I have made one video also. We have 3 videos on technology transfer. If you are interested, you can watch them. So execution of agreement happens. There are different terms and conditions. Buyer and seller of technology, they negotiate and they enter into agreement. There is one of the important clauses, royalty, how much money you are getting by selling of your patent. So this is how the final agreement is executed, and technology transfer relationship starts from here. One example I'll give you, disposable blood bag technology. So earlier blood was transported in glass bottles. So then came a technology of disposable blood bag. It was very useful because there was no need to have, sterilization done, and collection was easy, storage, transportation was easy with the blood bag compared to the glass bottle. And this institute, Sri Chitra Thirugal Institute of Medical Sciences in Trivandrum, they came up with blood bag technology. They made phenomenal money with this technology. They granted first license to Peninsula Polymer. In 1983, they could fetch 0.3 million as a fees, 3% royalty for 10 years on non-exclusive mode in 1983. So similarly, they granted more licenses. Second license was granted to Hindustan Latex 1991 at the rate 1.65 million royalty. Then 3% of royalty for 10 years on non-exclusive mode. The product was introduced in the market at the rate of 10 rupees a bag compared to 30 rupees, the cost of Japanese bag that was earlier available in the market. During 1994, 2 other licenses were J. Mitra and Company, Electromedical, and Allied Industries. Each of these companies, they paid 4.5 million as fees and 3% royalty for 10 years on non-exclusive mode to both the companies. So this is how, huge amount of revenue was made by licensing these technologies in the market. So this is the value of having a patent. So if one has patent and patent has value, then licensing or assignment is the best way to bring technology in the market. There is another case of jasmine. Tamil Nadu is largest grower of jasmine flowers. So they were able to fulfill the needs of Indian market very well. But when it came to exporting the flowers to distant countries, there was a problem that travel time was long, and lots of flowers, they will get spoiled on the way. They were struggling. The growers were struggling to find solution to this problem. Now, question for you is, here is a problem. Problem is that there are flowers, but due to travel time, the flowers get spoiled. So what could be the solution to overcome this problem? What could be solution to transport flowers to distant countries distant countries where the travel time is 24 to 46 hours. What could be the possible solution to transport flowers without any spoilage? What is the solution of this problem wherein the flowers get spoiled during travel, and there has to be a way to transport flowers without much spoilage? So Deshmukh Vittal says preservation in humid and cold conditions could be a solution. That's good. Anyone else? Can you come up with the solution? See, there could be many solutions to it. One solution could be that we should have a better aircrafts. Other solution could be that we should pluck flowers when they are in bud stage. Arvind says ease of doing business, set up the industry there. Yeah, that could be a possible solution, that you can set up, the farm in the country itself, in the other country itself, or tie up with some local people there and, grow the jasmine flowers in those countries. So when in the companies some problem arises, so this is what they do. They ask their teams to come up with all possible strange, vague, stupid solutions, and then probably they pick up one or two solutions that are doable. So in this case, they worked on the packaging solution. So challenges here were that after harvesting, Dubai and Singapore market took 24 hours, New York market took even longer, 36 to 48 hours. So high level of post-harvest losses were happening, 35 to 40% losses were happening, and this is a very big loss. And flowers were delicate, and fragrance will also go the moment they reach Dubai, New York, Singapore markets. So solution was there was work done in packaging solutions, and with help of ICR NIP project, the solution was worked out, and the solution was that the flower buds were plucked, and they were treated with boric acid, and the strings were packed in ventilated corrugated fiber board boxes, and then they were airlifted to Dubai market. And surprisingly, the loss of fragrance and loss of flowers was minimum in such a case. So this was done for Dubai market, and there was further addition in the packaging technology that was worked upon when it was to be airlifted to US market. Then same fresh flowers were plucked, treated with boric acid, and ice gels were placed over the small boxes, and further they were covered with aluminum foils, and then they were airlifted to US market. So the condition of flowers was much better than before in such a case. And on the left side, you see, the patent was filed for this particular technology by Tamil Nadu Agriculture University. And on the top, you can see application number 1370 CHE 2010. So 1370 is a serial number. CHE indicates that it was filed in Chennai Patent Office, and year of filing was 2010. Now, I would like you to observe this particular thing, a date of filing, 14th May 2010, 4 o'clock, 3 minutes, 35 seconds. So how precisely the patent office allocates the date of filing. And this date of filing is called as priority date. And priority date is a kind of, the meter. So lots of timelines are calculated from this particular time. The expiry date of patent is calculated from this time. So everything related to the patent is calculated from this priority date. So impact of the technology was the shelf life increased, post-harvest losses were reduced, and the growers, they could make more money using this particular technology. And they got patent also later on. So if you want to read more about this technology, I've given the link. So if you want, I can share it with you after the talk. So I'm almost done. I'll just give you some examples, and we'll have some 7-8 minutes for discussion. Another technology, NDRI, National Dairy Research Institute, they developed low cholesterol ghee. And they licensed this technology to Patna Dairy, and this product is successful in the market. You can see this product in the market. Now, in this product, Live Light is the trademark. Post-it is again one of the very successful products. And what is most innovative thing in Post-it? What is innovation in Post-it? Audience, can you tell me what is innovation in Post-it? What is innovative part of Post-it? It is the glue, composition of the glue, which is innovative, because you stick Post-it to any surface, and when you remove it, the surface is intact. So that's why, the innovation in Post-it is the glue, composition of the glue. Okay, then this product is called as Snuggie. Snuggie is the trademark. So you must know difference between the technology and the trademark. So Snuggie is kind of fleece blanket that can be worn. So this was a very popular product and it generated a huge amount of revenue. But if you look at the product, it's a simple product. So sometimes what happens that the patents are very good, but product does not perform well in the market. On the other hand, sometimes the technology is not that grand, but the product does very well in the market. So it all depends upon what consumer needs. End of the day, how much money you are going to make out of your technology is how well you think of consumers' demand. This is a beautiful product. It is called as Doggles. It is goggle style sunglasses. It is meant for pets so that the eyes are protected from UV light, debris, dust, and none other than Ray-Bans is manufacturing this beautiful product. This again is a successful product in the market. Push ball, I'm sure you would have used push balls when you were small. So they also made good business, and how they were invented, the inventor just took some strings of rubber band, cut it into a kind of ball, and this product became so popular, and they did a very big business in during the Christmas times, and this product is popular even today. So now I'm almost done now. So IPR is a career. So as an advocate in patents as a field, you can be a good person to handle revocations, litigations, oppositions related to patents. And apart from that, there are lots of technology transfer agreements in the companies, and you have patent docketing as a big subject, wherein different timelines, different fees has to be calculated, and the cases have to be docketed. Some companies, they have very big patent portfolio of thousands of patents. So their patent docketing becomes a very important subject. Then further patent valuation, transfer of technology, patent commercialization, these things are very attractive for the lawyers because there are lots of negotiations that happen in the process. Lots of agreements need to be drafted. So there you can think of establishing yourself. Trademark is one of the best areas to practice in IPR for advocates. So every company you have trademark, not just name of the companies, but some pharma companies or other companies, they have n number of products. So in pharma companies, you see they have range of products, and all trademarks, they have to be registered. After they are registered, you have to track if somebody else is using the similar trademarks. Then legal notices come into picture. Then the renewals have to be paid. So trademark valuation is also another subject. So trademark is most lucrative area to practice in for the advocates. Then copyright is important, and you have lots of cases coming up from entertainment industry, design, geographical indication. So these are other areas you can practice in. So in geographical indication, design, copyright, trademark, so you don't need any other qualification, but your LLB is good enough to enable you file and prosecute applications, and all areas of litigation in IPR are open for you to practice in. And you are a good candidate to work either in law firms or R&D departments of the companies. I have many friends who are working in R&D departments of the companies. And teaching, of course, is anytime you can opt for teaching as a career. And we have one video specifically on IPR as career for lawyers. You can go through that. We have very active YouTube channel, so you can subscribe and watch videos. Lots of freely downloadable books are available, and if you want, you can download them. We have free course on intellectual property rights. It is a 45 minutes course, and you can register for it anytime you want. And then there is certificate course in IPR. So for this course, we tie up with the universities, and we offer these courses in the universities. So that's all from my side. We are well in time, and we have 5 minutes for discussion. Please, you can either unmute and speak, or you can just put in the chat box. Ram Bala has asked what is different between selling and offering to sell. So selling is directly selling. Offering for sale is like, you are selling through somebody else. Okay, there is one more question here. Okay. Life of patent is 20 years. Can it be renewed? Beyond 20 years, there is no scope of getting any kind of extension. So 20 years is like the cutoff. Okay. Dr. Okay, Arvind is saying, thank you so much. Highly informative, wonderful presentation. Thank you. Thank you so much. I'm glad you liked. You can come up with, if you have any doubts, you can reach out to me later also. So Rambala is asking, here is a mere patent registration number without hard copy of registration legally adequate to establishing IPR rights during court disputes. Rambala, during disputes or litigations, you either need original copy of the patent, or you need to you need to obtain certified copy of patent from patent office. When I say certified copy, it is like it comes with copy of the application comes with the original seal of the controller of patents. Aishwarya Suresh is asking, plastic products can be harmful for the environment. Any products of such products, can it be patented? So most of the things depend upon how you are writing your patent specification, but plastic as such is not supposed to be a product which can be denied a patent. So and lots of things depend upon the way you write your specification. If I write a specification and my patent talks about a device to murder a person, so I may not get a patent on a device to get a patent. But if I say that a device to ensure national defense and security, I may get a patent. Okay, so lots of things depend upon how you are writing your patent specification. So Dr. Pradeep is asking, teaching techniques can be patentable. I don't think so, Dr. Pradeep, because teaching techniques, they cannot be categorized as inventions. So invention is something tangible, like, if you have any, just to give you one example, any slate kind of thing that can be used for teaching, then that slate kind of thing can be patented, but the methodology as such, I doubt. Rambala is asking, can you define what is a technical problem? When I gave you example of jasmine flowers, technical problem was that flowers were getting spoiled. Now, when you write a patent specification, you have to specifically write what technical problem you are addressing in your patent specification. Rishabh is asking, please tell us about greening of a patent. So Rishabh, the term is evergreening of patents. So evergreening means that I invent paracetamol today. Okay, so paracetamol the paracetamol patent has 20 years from the date of filing. But before my paracetamol patent gets expired, I come up with one more improvement in paracetamol and file another patent before expiry of first patent, so that I have another monopoly in the market for 20 years. Now, before my second patent expires, I file another patent, which is just a mere modification of my first and second patent. So this way I try to, maintain my monopoly in the market for a longer time. So this is called as evergreening of patent. Dr. Ratnakar is asking, when there is a private-public collaboration in space technology, if the private firm has to file the patent for their innovation, are they eligible? Dr. Ratnakar, definitely they are eligible. Kashmira is asking, does Origin IP conduct any course on procedures in technology transfer? Kashmira, we do lots of trainings and we do on technology transfer as well. Ashwarya again has a question. Surgical masks are not patentable and they are harmful at large. Can it be patented? Ashwarya, here you have to understand that what is required to get a patent. If surgical mask is novel, it is non-obvious, it has industrial use, it can be patented. Second thing is to be checked is whether it falls in section 3 or not. So as an inventor, I think examiner has to take this call, but as of now, I don't think surgical mask can be denied a patent. And I thank all of you for your patience, and we finished well in time. So thank you so much. Have a good day. Be safe and take all precautions. Protect yourself from COVID and have a good day. Thank you so much.
Thank you.
Thank you, Ms. Bindu, for an interesting and interactive session. We now have Mr. Shivram Krishna Prakash, who will be addressing the gathering on the topic Artificial Intelligence and Patents. Wing Commander Shivram Krishna Prakash is a veteran Air Force personnel and is presently the Senior Corporate Counsel at Cisco Systems. Bindu, ma'am?
Yeah, I'll just stop sharing.
Okay, ma'am. Yeah, thank you, ma'am. So we now have Mr. Shivram Krishna Prakash, who will be addressing the gathering on the topic Artificial Intelligence and Patents. Wing Commander Shivram Krishna Prakash is a veteran Air Force personnel and is presently the Senior Corporate Counsel at Cisco Systems India Private Limited and the former Director on Board of Cisco Commerce India Private Limited. Wing Commander Prakash commenced his career with a short stint in the Central Bank of India. Thereafter, worked with the IAF for 23 years, 7 years as ATC officer, and 16 years as JAG officer. His stint in the corporate world has been with the legal department of 2 companies, that is IBS Software Services and Cisco. Wing Commander Prakash is a multifaceted 360-degree corporate lawyer. He was the first IAF officer to undergo the prestigious Judge Advocate Staff course with the US Air Force. I now request Mr. Shivram to proceed with the session.
Thank you, Chandana. Can you just let me know if you can hear me and also see my screen? I'm trying to share the screen.
Sir, you're audible, but your screen is not visible.
Yeah, it's just coming up.
Yes, sir, it's visible.
No?
Yes, sir, it's visible.
Okay, thank you. Good afternoon, everyone, and thank you for taking time on a busy Monday and joining us to be part of the national workshop on the recent trends in IP laws. I wish to thank Dr. Anubha Singh, the Vice Chancellor, Alliance University, for the warm welcome, Dr. Ray Titus, Dr. Kiran Gardner, Dean and School of Law, Dr. Upankar, Dr. Aisha, my research guide, and all faculty members for providing me an opportunity to be part of this conference and present my thoughts. I have prepared a presentation to go through the topics that I want to cover today. And since my PhD research title is connected with artificial intelligence, I will be mainly touching IP with AI, even though at places there could be an overlap with what the first two speakers have spoken. In my presentation, I plan to cover the following topics. I shall first introduce you to artificial intelligence, then touch upon the different types of intellectual property. We did hear that in detail in the previous session. I will then go about to talk about what's a valid patent claim, then touch upon the potential legal issues with AI inventions, talk of 3 pillars of artificial intelligence in the 4th industrial revolution, then touch upon AI related patent applications. I will then go on to discuss computer related inventions and treatment by various patent offices across the world. We'll talk of the 3 categories of AI inventions and then discuss about the top 5 patent offices of the world. We shall then briefly touch upon 3 case laws and then move on to a couple of questions for IoT innovators as AI evolves, artificial intelligence evolves. And then again, get back to the monkey selfie case study, which was touched upon by the first speaker, but I thought I should repeat it and give a little more perspective, basically my perspective to the case. Then I shall provide you with some statistics on the countries and companies which are leading in AI patents, and also talk about the corporate strategy to boost patent filing by employees. And finally, I shall summarize whatever I have spoken and then conclude and provide my conclusion. When we talk of artificial intelligence is the ability of computers and machines to perform mental tasks commonly associated with humans, such as learning, reasoning, and problem solving. Although core AI technologies, including neural networks, deep learning, and rule-based systems have been known for long, they have developed dramatically in the past decade, bringing AI to the forefront of our lives. John McCarthy in 1955 had defined artificial intelligence as making a machine behave in ways that would be called intelligent if a machine were so behaving. It is only recently that artificial intelligence technology has undergone a rapid progress and has become one of the hottest trends of the present world. Now, why has this happened? The rapid expansion of AI in recent years is basically due to several interrelated factors, like improvement in processing power. When I say processing power, the computer processing power. Development of powerful computing architectures specifically designed for AI applications. Availability of large volumes of data which are critical for training AI models. And better core AI models and techniques, mostly neural networks and deep learning. Tasks that humans can easily and intuitively perform, such as recognizing a face in an image, have traditionally presented a challenge for automated data processing. But today, AI is able to match or even exceed our capability in these areas. The impact of AI on our day-to-day lives is intensively being deliberated upon in almost every corner of the world. And this aspect has garnered the much needed attention, not only from business sector and academia, but also from the policymakers and the judiciary. Now we shall briefly dwell upon the 4 types of intellectual property protections. We've heard that in the previous session, but I thought I should even if it is getting repeated, it would be good, because then when we talk of AI and intellectual property, it will be good to have this at the back of the mind afresh. The 4 major categories of intellectual property protections are trade secrets, copyrights, trademarks, and patents. Trade secrets, they refer basically to specific private information that's important to a business because it gives the business a competitive advantage in its marketplace. If a trade secret is acquired by another company, it could harm the original holder. And we know for sure now, like after listening to the previous speaker, that stuff like Maggi noodles, KFC, Coke, Sprite, etc., all these are basically trade secret formulas of those respective companies. In marketing parlance, trade secret is also called as secret sauce. When a person or business holds a trade secret protection, others cannot copy or steal the idea. In order to establish an information as trade secret and to incur legal protections associated with trade secrets, businesses must actively behave in a manner that demonstrates their desire to protect the information. Trade secrets are protected without official registration. However, an owner of a trade secret whose rights are breached has to prove their claim to the trade secret before a court of law in case they wish the court to pass orders to prevent the person who stole the secret from using it. The next is copyright. Copyright and patents are not the same thing, although they are often confused. Copyright is a type of intellectual property protection that protects the original works of authorship, which might include literary works, music, art, and more. Today, copyright also protects computer software and architecture. Copyright protections are automatic. Once you create something, it is yours. However, registration of copyright will be more helpful to file cases of infringement in courts. When we talk of copyright, one thing that comes to my mind, I don't know how many of you got a chance to watch that recent Malayalam movie, Drishyam 2. All of you must have watched Drishyam 1, which was remade in Hindi. In Drishyam 2, there is a short mention of copyright where the hero sort of writes the story into a book and publishes it. And he does not do a mass scale publishing of the book. He actually, publishes the very short copies of the book in another author's name. And then later on, he tries to, it is connected into the story, and it's brought about that this publishing was done basically to hold copyright in the story. So copyright, as you know, like if you publish it, it is good because it gives you more credence. You get the date. You saw in the previous session, the speaker had shown you how the dates are recorded when you file any application, even for patents, the date and time is recorded. But if you don't publish it also, still you hold the copyright so long as you're able to prove that it was your original work. The next is trademarks. The next type of IP protection trademarks, basically refer to phrases, words, or symbols that distinguish the source of a product or services from one party to another. For example, the Nike tick mark symbol, which we all know, easily one can identify that the trademark belongs to Nike. Similarly, while patents and copyrights can expire, trademark rights come from the use of the trademark and therefore can be held indefinitely. Like a copyright, registration of a trademark is not required, but registering can offer additional advantages, as I mentioned earlier. The fourth type is patents, and as defined by USPTO or the US Patent and Trademark Office, patent is a type of limited duration protection that can be used to protect inventions or discoveries that are new, non-obvious, and useful. And such a new process machine that are new, non-obvious, and useful. When a property owner holds a patent, others are prevented under law from offering that for sale, making, or using the product. Now, on patents, I just want to give a small example of the Bajaj auto rickshaw, the rear engine auto rickshaw. I don't know how many of you are aware of it. When initially we had all the auto rickshaws with just the engines in the front, and there used to be it used to be a bumpy ride for anyone who sat at the rear seat. Then Bajaj Auto came up with this new concept of Bajaj rear engine. It's called as Bajaj RE, where the engine was kept at the rear side, and then because of the weight, the bumpiness reduced in these auto rickshaws. And definitely, and they made sure that they patented it before the product was launched into the market. As a result of which, TVS, which was possibly experimenting on the same lines, could not launch their product, and they almost had to wait for 20 years for the patent to expire, and then only launched the TVS rear engine auto rickshaws. So registration and not making the data available public prior to even applying for patent, as the previous speaker mentioned, is very important when you're working on patents. So in order for a patent claim to be valid, there are three things which are very important. One is it must be useful. Basically, it should be industrially useful. Second is it has to be novel. Basically, the invention should not have been something which somebody else has invented, or the invention should not have been described in any printed publication. And the most important thing is the non-obvious part. If an invention would not have been obvious to one skilled in the field, given prior art and knowledge common in that field, then it is deemed as non-obvious. In other words, some creative leap is required that places the invention out of the box. Basically, the crux is out of the box. Now let us talk of some of the legal issues that have come up with the AI inventions. AI questions the most conventional intellectual property legal principles, such as who is the author, who is the creator, is there originality, or is there any inventiveness. AI also makes it difficult to determine what is non-obvious. Everything is expected out of AI. Can a machine be an author, or can a machine be an inventor? Should AI generated inventions be considered state of art? When we all talk of Shakuntala Devi, we all say that she was a genius. But no one calls a computer a genius, because when you talk of a computer, the way the computer calculates, it's a given. Basically, we would say they are supposed to be doing what they're doing. There's nothing special about it. The next issue is who's the owner of AI generated works, and that's the most important issue. Is it the AI? Is it the human behind the AI? Or is it the human who's owning the AI? Or is it both? And the last issue is who should be held responsible for the creations and innovations generated by AI if they encroach upon other people's rights or violate other people's legal provisions. Again, is it the AI owner or the person behind the AI? With the increasing prevalence and increasing capability of AI, these are some of the intellectual property law issues that the legal fraternity has to resolve. Now let us talk of the industrial revolutions. We all know that we are in the fourth industrial revolution right now. The first one was basically the steam engine time. Then we had the printing machines and the mills when it was 2.0. 3.0 we had the computers, and in 4.0 now we have the digital revolution, which also includes artificial intelligence. From 1.0 to 3.0, it was basically empowering corporations, but from 4.0, it's also started empowering people. Now let us talk of AI in the fourth industrial revolution. There are three pillars where AI is growing leaps and bounds under the fourth industrial revolution. One is healthcare, informatics, and biometrics. Chemical sample screening and decision making today are as good as or even better than by a human operator. AI has and will continue to play a growing role in identifying protein structures, targeting drug interactions, and analyzing DNA and RNA sequences. The next one is automotive industry, or basically the self-driving cars or the autonomous cars. Use of artificial intelligence in self-driving vehicle technology is gradually becoming popular, and this will require real-time processing of a massive amount of vehicle-to-vehicle data and a vehicle-to-everything data. The last piece, industries. Most of the industries use artificial intelligence for automated predictive analysis, data analysis, process design, defect detection, etc., all to help the factories run smoothly, efficiently, and to consistently produce high-quality products. Till now, we have had an introduction to artificial intelligence. We've talked of different types of intellectual property. We've done a little deep dive on patents, and thereafter, we discussed various legal issues that have come up with AI inventions, and then touched upon the use of AI in the fourth industrial revolution. Now let us look into some statistics on AI-related patent filings. If you look at the graph on your screen, you'd see from 2008 to 2018, the graph is growing steadily. And in fact, during the last couple of years, the growth has been very high. I shall leave the screen for about 30 seconds for you all to have a look at it before I go to the next slide. Computer implemented inventions are treated differently by patent offices in different regions of the world. Software patents. In US, the basic philosophy is that a software invention is patentable if it meets two requirements. One is it is unique, that is, it is something which is new and it's tied to a machine. And the second is it's tied to a machine. Now, this was not the situation in US before June 2014. Prior to June 2014, you could sort of even get a patent for a software in the US. On 19 June 2014, the United States Supreme Court ruled in Alice Corporation versus CLS Bank that merely requiring generic computer implementation fails to transform an abstract idea into a patent eligible invention. Going to Europe. In Europe, software on its own is not patentable through the European Patent Office or the EPO. it can only be protected as a computer implemented invention, which is defined as a software program that performs some novel and useful function within a hardware device that is itself being patented. Coming to Asia, countries like Japan, India, and South Korea typically apply the same exceptions as the European Union. That is, software cannot be patented unless it is an element within hardware invention. Historically, China has viewed software patents the same way, though the recently released patent examination guidelines suggest that China is becoming more receptive to the idea of patenting software as a separate entity. Now, when we look at AI, the same approach which applies to computer implemented softwares also would apply to AI. For example, the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats makes a technical contribution. The classification of digital images, videos, audio, or speech signals based on low-level features are other typical technical applications of AI. The impressive developments in the area of AI have sparked suggestions that AI could invent just as humans can, and that it should be accepted as an inventor. From the perspective of inventorship, there are three categories of AI inventions that can be identified. One, human-made inventions using AI for verification of the outcome. Second, inventions in which a human identifies a problem and uses AI to find a solution. And the third, AI-made inventions in which AI or artificial intelligence itself identifies the problem and AI itself proposes a solution, all without human intervention. In the first two categories, artificial intelligence is used as a tool for human inventors, augmenting their capabilities. In the third category, or the AI-made invention or the pure AI-made inventions, scientists seem to agree that AI, which could invent independently of human directions, instructions, and oversight, is a matter of undefined future and thus science fiction. The European Patent Convention, EPC, requires that an inventor designated in the application be a human being and not a machine. The designation of an inventor bears a series of legal consequences, notably to ensure that the designated inventor is the legitimate one and that they can benefit from the rights linked to this status. To exercise these rights, the inventor must have a legal personality that AI systems or machines do not enjoy. We will get into some case laws a little later, but before that, let us talk of the 5 largest IP offices in the world. The 5 largest IP offices in the world receive over 80% of all patent applications, collectively known as the IP5. They are the European Patent Office, the Japanese Patent Office, the Korean Patent Office, Chinese, and the United States Patent Office. All these 5 offices cooperate on a variety of projects to improve and harmonize the global patent systems. Since 2018, they have explored a joint approach in response to global technological developments. In 2019, the IP5 offices decided to advance their cooperation in the area of new emerging technologies, also known as NET, and artificial intelligence by setting up a special task force to coordinate their initiatives. By June 2021, the task force aims to develop a comprehensive roadmap for the IP5's approach to new emerging technologies and AI. Now let's have a look on the statistics with respect to countries and companies which are leading in AI patents. China has the most AI patent applications. 4636 is the number. USA is the next with 1416, Korea 532. As regards companies, IBM has the largest portfolio of AI-related patent applications with 8,290 applications in the world. Microsoft 5930, LG Electronics 731, Ping An Technology with 308 applications. With respect to number of patents granted as a company, Intel is the highest with a massive 45,591 patents. Now let us jump into some case laws. The first one is between Coogee, Australia and Hypersport International. The Coogee case was the first instance in which computer-generated product was contemplated in the context of copyright before an Australian court. Coogie utilized a computer program to help generate the patterns and stitch work on jumpers. Coogie brought a claim against Hypersport for copyright infringement relating to its stitch fabric as a work of artistic craftsmanship. What Hypersport did was they basically recognized the method that Coogie was using to create the stitch work and effectively came up with their own computer program to achieve the same outcome. When the case went before the Australian court, it was held that there was no infringement because regardless of the fact that the product was same, the process to get there was different. As per courts, Hypersport had devised an entirely different program to achieve a similar outcome, and hence there was no copyright breach. The next case is Acos versus UCorp. Acos was a company that maintained a database containing all the data needed to generate some 200,000 material safety data sheets, or MSDS as they are called. MSDS are basically documents that provide health and safety information about products, substances, and chemicals which are classified as hazardous substances or dangerous goods. When a particular MSDS is required, a computer program in Acos InfoSafe system. InfoSafe system is the AI system which Acos uses. So that InfoSafe system assembles and displays the relevant data as an MSDS. UCorp, the second company, basically maintained a library of the MSDS, but the library which UCorp was maintaining was sourced by UCorp effectively from internet searches. Basically, it was all publicly available data. Acco claimed that UCorp had infringed its copyrights in various MSDS and their source code. When the case went before Justice Jessup, he held that copyright did not subsist in the source code as it had not been solely authored by a human, and hence the code could not be considered as an original literary work. Basically, he was looking at the way in which the data was being generated, and it was being done by InfoSafe, which is an AI system in Acos, and therefore the judge said that there was no human intervention, and therefore it has not been solely authorized by a human. This decision was appealed, but it was not overturned. The third case, or the most important case, or the recent case on patents, is the one by Stephen S. Thaler versus Controller General of Patents, Design and Trademark, and this is also famously known as the Dabas case. Plaintiff Stephen Thaler, or Dr. Thaler, had been developing, owning, and operating advanced artificial intelligence systems capable of generating patentable output under circumstances in which no natural person traditionally qualifies as an inventor. Basically, the AI machines that he owned were inventing on their own, and there was no human intervention. So these were all AI-generated inventions. One such system that he invented is called the Dabas. Basically, the acronym of Dabas is Device Autonomous Bootstrapping Uniform Sensibility. And this Dabas created two patentable inventions called the Neural Flame and Fractal Container. Dr. Thaler filed applications with USPTO on 29 July 2019. And because no natural person qualifies as an inventor of applications, and because they were generated by Dabas, the AI, on its own, the application had listed Dabas as the inventor. Dr. Thaler, as the owner and developer of Dabas, was listed in the application as the patent applicant who is entitled to own the applications as well as any patents that could ultimately be issued. USPTO rejected the applications on the basis that they did not identify an inventor who was a natural person, which was mandatory as per the patent statute language and the Federal Circuit decisions. In 2019, Dabas was also refused patent by the European Patent Office, where Dr. Thaler had simultaneously filed a case, as they also focused more on formal rules on the ground that EPC also requires the inventor to be a natural person. There are two appeals pending against this, numbered J820 and J9 of 20. The UK Intellectual Property Office, the third patent office, also declined to grant patent to Dabas on substantive aspects requiring the inventor to be a human being. When the UK Patent Office rejected the application, they also said that there appears to be no law that allows for transferring of ownership of the invention from the inventor to the owner in this case, as the inventor itself cannot hold intellectual property. Basically, what they try to say is that since the AI machine itself cannot hold intellectual property as it's not a human, it has no right to transfer the IP to Dr. Thaler. Let's now look into a couple of questions for the IoT innovators to consider as AI evolves. Is trade secret protection a viable formula to take care of AI inventions? Trade secret protection is broad, which not only covers secret formula, but also any information that has economic value, as these information are generally not known to others. Unlike patent protection, trade secret protection requires no government process and lasts as long as the information retains value and secrecy. These advantages mean new ever-changing advanced algorithms rooted in AI inventions may soon be attempted to be protected by corporations as trade secrets and not patents. Next is for software. What about copyright? AI helps write software and software can receive copyright protection. But most copyright offices across the world only register copyrights with human author. Copyright only protects works from creative powers of the mind. Courts have said that corporations formed by humans can own a copyright, but an animal cannot. With that, let's go to the monkey selfie case. The monkey selfie copyright dispute is a series of disputes about the copyright status of selfies taken by a monkey macaque. Macaque is a breed, using the equipment belonging to the British nature photographer David Slater. Macaques are monkeys. Why? Because they have tails unlike apes, but they look like apes and their arms and legs are of the same leg as an ape. So the dispute involves Wikimedia Commons and the blog TechDirt, which have hosted the selfie images taken by the macaque in July 2011. David Slater objected to this, stating that he holds the copyright. PETA intervened and said that the macaque should be assigned the copyright. Slater argued that he has a valid copyright claim as he had engineered the situation by setting up his camera equipment in such a way that a selfie picture might come about. Wikimedia Foundation's refusal to remove the pictures from its library was based on the understanding that copyright is held by the creator, and a non-human creator, not being a legal person, cannot hold copyright, and thus the images are in public domain. Slater stated in August 2014 that as a result of the pictures being available on Wikipedia, he had lost at least £10,000 and his business as a wildlife photographer was being harmed. In December 2014, the United States Copyright Office stated that works created by a non-human, such as a photograph taken by a monkey, are not copyrightable. While this was the order passed by the United States Copyright Office, a number of legal experts in US and UK have argued that Slater's role in the photographic process may have been sufficient to establish a valid copyright claim, though this decision would have had to be made by a court. In a separate dispute, PETA tried to use the monkey selfies to establish a legal precedent that animals should be declared copyright holders. In the meantime, Slater had published a book containing the photographs through a self-publishing company called Blurb Inc. In 2015, PETA again filed a lawsuit against Slater and Blurb, requesting that the monkey be assigned the copyright and that PETA be appointed to administer proceeds from the photos for the endangered species benefit. In dismissing the case of PETA, the court ruled that a monkey cannot own copyright under the US law. PETA again appealed in September 2017, and that's when the photographer David Slater agreed to a settlement with PETA, stating that he would donate a future portion of the revenues from that book to wildlife organizations. In April 2018, the appeals court confirmed that animals cannot legally hold copyrights and expressed concern that PETA's motivations had been more to promote their own interests than to protect the legal rights of the animals. Now, when we look at the UK copyright law, we can see that there is a provision which stipulates that if a work is computer generated, then the author is taken to be a person who facilitated the work to be created under the Copyright Designs and Patents Act 1988. On similar terms, we can assume that the author of an AI-generated work would also be the one who made the necessary arrangement for creation of the work. When we also look at the Indian copyright law, Section 2D clearly states that the author in relation to any literary, dramatic, musical or artistic work which is computer generated would be the person who causes or caused the work to be created. Let us now dwell into a little bit of the corporate strategy to boost patent filing by employees. Why are patents important for corporations? Patent, basically, if a company owns a patent, it acts as a deterrent for others to copy them. The respect for their portfolio minimizes litigation and provides a company a freedom to operate in the current and future markets. Patents also provide company with an exclusivity, differentiate them from other products and services, and they sort of lower their competitive product costs. Without patents, others could easily copy one's inventions, and therefore companies would not like that to happen because that would affect their profitability. In cases where companies want to facilitate trading and reach mutual agreements, having a patent helps them by getting them a seat at the table for discussion on patent pools. Companies, the valuation of most of the companies is basically also done. Patent plays an important part actually in the valuation of most of the companies, and therefore every company tries to have maximum amount of patents with them. The next slide, if you see the image there on the right side, it's basically about the smartphone competitor patent suits. If you all remember the opening address, Dr. Anubha did mention in great detail about the mobile phones, our dependency, and the various kinds of IP a mobile phone holds. The slide on the screen basically depends the web of patent cases in the mobile space, and the previous speaker also mentioned a little about the patent litigation in mobile space. Some patents in the mobile spaces are standard essential patents. Use of patented technology is required to meet certain standards promulgated by international standard setting organizations. Now, how does this work? First is the companies sort of develop a new product and then they apply and try to get a patent to the product. Thereafter, they sort of work with various regulatory agencies and ensure that that particular patent becomes a standard. Now, what the regulatory agencies do is prior to incorporating a particular patent into a standard and making it an SEP, they require the patent owners to agree to license these SEPs to other industry participants on fair, reasonable, and non-discriminatory terms. These are also known as FRAND terms, F-R-A-N-D, FRAND terms. This is intended to eliminate the risk that the patent owner will selectively prevent other market participants from implementing the relevant standards. When this does not happen, or the other party finds right or dubious means, litigation occurs. Litigation also occurs when the dominant party wants to kill the weak party or coerce them to get into an agreement or settlement. So what do corporations do to sort of motivate their employees to come up with patents or work on patents? So every employee, especially the ones who are in the R&D side, like when we're talking of the IT sector, the engineering side, when you're talking of pharma, the scientists who are working on various medicines, etc., they're all motivated to sort of apply to come up with new inventions so that the company can apply for patents. And at each filing, each inventor on a patent application receives XXX amount of rupees. That's the first motivation factor that most of the companies do. And thereafter, if the patent is issued, then each inventor on a patent application again receives an XXX amount of rupees. And in most of the corporations, in fact, the corporations do have a great amount of business intelligence, and so if you look at the amount which is being given by A company or B company, you would generally find that they're almost benchmarked, so that it doesn't happen that a particular employee sort of works on a particular project in A company and then jumps to B company to sort of get his patent filed from there. So these are taken care of. They're very intelligent and they know how to do their business. The value of award is also normalized based on locations, and in some cases, some companies also grant RSUs. They also grant restricted stock units to employees. They also grant promotions. And as I mentioned in the first bullet point, each inventor, when I say each inventor, every patent may not necessarily be having just one inventor. There could be multiple people who have invested time and energy and knowledge in a particular patent. And so all of them would generally be named in the patent application if they are major contributors. If they are minor contributors, they just get the reward, and that's how it is done. So when they are major contributors, corporations also permit employees to be filed as joint patent holder in applications, especially so that it's a motivation for them. And then if you have happened to talk to engineers in various companies who hold patents, you'd realize they would say, I hold 5 patents, I hold 10 patents. It's because they've been working in XYZ companies and they have been part of the patent process of that particular company. So let me now sort of summarize whatever I've been speaking for the last 40 minutes or so. AI or artificial intelligence has the potential to challenge the core legal principles that are edifice of patent law. Whether an AI generated invention should be given protection under patent law, and if so, who should be considered as an inventor for such created inventions, is the most fundamental question that needs to be addressed urgently. Some scholars are of the view that granting patent rights to AI generated inventions would act as a catalyst for new and advanced innovations, which would be difficult to achieve through human inventiveness solely. Others argue that granting patent protection to AI generated inventions will raise the cost of research and development, increase the monopolies, thereby impeding innovation. In order to understand the possibility of patentability of AI related inventions, one needs to recognize that an AI related invention is not a single invention, but a combination of several inventions or processes. It could be a computational or a mathematical method or an algorithm or a combination of both. In India, we have an absolute ban on patentability of algorithms and computer programs unless it produces a technical effect or technical contribution, which will be difficult to establish in an AI-related invention. According to Section 3K of the Indian Patent Act, mathematical and business methods, computer programs per se, or algorithms are categorized as non-patentable subject matter. One could argue that copyright laws could indirectly protect the algorithm once incorporated into the code. But since copyright law does not protect the inventive concept behind the expression, AI-related invention cannot fully be protected under copyright law. Another problematic issue is the non-obvious rule connected to patentability of an idea. Patent laws require that an inventive concept be non-obvious to a person skilled in the art of that concept. In the world of AI and its capacity to process higher levels of intelligence and predictability, there is a likelihood that all inventive concepts could be considered obvious to an AI, and if so, that will eliminate the stipulation for patent protections entirely. On a concluding note, I would like to say that it is important to revisit the intellectual property laws to bring them in conformity with the present technological developments, which are defining the future of this world. Assigning authorship and inventorship to non-humans is a novel way to promote the growth and development of AI, which will boost the appetite of this world for more invention. However, instead of going for the complete overhaul of rules and guidelines currently set in place, it would be feasible for the regulators to modify and restructure the present laws in order to avoid complex and lengthy process and to prevent the law from getting static. The regulators have a big responsibility of creating a harmonious approach between the protection of rights of citizens, individuals, and the need to encourage technological growth while deciding upon AI-generated intellectual property. The commercial implication of AI is in future investments by corporations in the areas of innovation, where AI will be dependent and the manner in which IP ownership created by AI is acknowledged and decided. If the understanding is that since these works are created by non-humans and hence have no owners, then the commercial value of these newly created products would be nil. Under such circumstances, companies may not come forward in future to invest millions on systems that would have no return on investment. Finally, even if AI can't be named an inventor, there is a human involved in the process. Sorry. And the most common type of AI today is likely to have a human who would be interpreting the results. Hence, If patentability for AI-generated invention is considered desirable, a possible solution could be to grant ownership directly to the company or the person operating or owning the AI. That would solve the dilemma which is there or which has been created by the Dabas case. Thank you very much. I've concluded, and if there are any questions, I can take them.
Thank you, Mr. Shivram, for providing a detailed and clear picture about AI inventions and patents. We now have Mr. Gaurav Singhal, who will be addressing the gathering on the topic, trademark filing trends in India and recent judicial interpretations on trademark laws or principles. Mr. Gaurav is an expert patent drafter who knows the ins and outs of the patent processes and the innovation ecosystem around the world. He's accustomed to handling drafting, patent specifications, and responding to office actions or examination reports for various jurisdictions, including USPTO, EPO, and WIPO. Mr. Gaurav's qualifications include Masters in Business Laws from National Law School of India University, Bangalore, LLB from Indian Institute of Technology, Kharagpur, BTech in Computer Science from Uttar Pradesh Technical University, India. Mr. Gaurav has around a decade of experience as a technology attorney specializing in patent and other forms of intellectual property. After a stint with Siemens for around 4 years, he went on to found PatriCode. Recently, in 2017, PatriCode rebranded itself to Singhal, where he is furthering on a path to keeping its clients legally immune, commercially progressive, and predominantly innovative. I now request Mr. Gaurav to proceed with the session.
Thanks, Chandna. Somehow you people may not be able to see my video. Reason being, it's not firing up. The camera is not firing up. So I will share my screen as of now. Just a second. Please confirm, is my screen viewable?
Yes, sir, it's visible.
Okay, thanks. Thanks a lot. Thank you, Chandana, and thank you all for providing me this opportunity to be before you people, and so that I can put up some of my thoughts, which I've observed in due course regarding trademarks and how the filing trends have been moving with respect to India, and how the legal principles have been interpreted by judiciary as of now, like in last 1.5 years, 2 years. So I will put up a few points over it, and that's how we will look into how trademark laws are developing in India. So as I've told you, like there would be two parts. Firstly, I will just brief you like how the trends are being, and then we will move to judicial interpretations. So okay. So if we see in last 5 years, we will see definitely we are moving on the higher side. That means people are taking more cognizance about their trademarks, the brands, the logos which they have been using. If you see in 2013-14, the filings were around 2 lakhs, which has been increased to almost 3.2 lakhs in last few months, last few years. Yeah, I think so. Somebody, Mr. Hanuman Prasad, has raised his hand. Is there anything which I can help out? Maybe let's take the questions towards the end if that is possible. So in 2017 and 18, if you will see, it was like almost 2.3 lakhs, which were the filings, total filings, which has been increased to almost 3.25, which is a good jump. And we are seeing year on year, there is regular filings which are happening, and that means Indian traders, Indian businesses are giving due respect to the IPs, and they are looking towards judiciary in a more better fashion. They are looking towards judiciary that it could do the justice for the trademarks which they have filed for. So moving towards the next one, which are the top five states by number of filings? Again, this data is from 2018 and 19, and what I'm presenting before you is from the annual report of Indian Patent Office. So there was a section from which I have taken it up. So if you will see, and definitely we should interpret about the business, how the business is moving with respect to the trademark filings. If you will see, the top one is Maharashtra, thereafter Delhi, thereafter Gujarat, Uttar Pradesh, and Tamil Nadu. And of course, Karnataka was just following thereafter Tamil Nadu. But if you will see, the maximum business concentration would be around Maharashtra, thereafter Delhi, thereafter Gujarat and Uttar Pradesh, and then Tamil Nadu. So it will give a fair overview, like probably how the business hubs would be at which all locations, because in India, trademarks are mostly when we say like jurisdiction wise or anything, like which all cities they are coming from, the business hubs would be at those places, and definitely there would be a higher chance the more business would be at that place. So these figures shows that how the business movement is they are state wise, and the data can be also interpreted in that fashion. Top five classes has been definitely pharma takes the major one. So most number of filings under trademarks are in pharma. There are various reasons, because they have a lot of products which they produce, and each has to be branded. And many times there are a lot of trademark litigation strategies which plays a important role while the trademarks being filed. Many times sometimes they are going for the offensive litigation, defensive litigation. So a lot of those scenarios comes up. That's why there are huge filings in pharma. Then food products, as we know, of course, this is one of the basic necessity things, and there are a lot of brands which are producing the food products. So definitely the number of filings uh, with food products is substantially high. Next goes for clothing. Again, this is also one of the basic necessity thing, and a lot of brands which has come up, specifically in scenario of Amazon, etc. When a lot of brands have been established in due course, because doing business and reaching out to more people has become easier with these platforms. Thereafter, scientific instrument, and then even education and entertainment services are in top five. So out of 45 classes, I have taken only top five. So I have to give again business overview, which sectors has been more prominent towards trademark filing. So these countries are who are the foreign countries who have been filing in India. So USA is top one with respect to 18-19 data. Then China. So difference between USA and China in itself is pretty huge. So that means a lot of business opportunities the US companies are seeing in India. Thereafter Chinese, UK, Japan, and Korea. So these are the top five countries who may be looking substantial business opportunities in India, and so also they may be considering the system, Indian trademark system, to be good enough to protect their intellectual property. So so providing that faith in the system, they would be filing these many trademark applications. So this is about the trends which has been regarding trademark filing with respect to India. Now let's move to the judicial interpretations. So first one which I have taking up is between Marico and another YouTuber Abhijit Bhansali. So here the court was looking towards whether disparagement, when you are using somebody else's trademark for disparaging it, can it be considered unauthorized use of a trademark or trademark infringement? So this fellow Abhijit Bhansali was running a YouTube channel in the name of Bearded Chokra, and what he used is he put up a video uh, which was reviewing the parachute hair, edible oil, and the review was whether it is really 100% pure or not. And there has been a lot of data which has been put across by him on the channel. The court definitely considered that it is not unauthorized use by a competitor. So this channel is not a competitor to Parachute Hair Oil. So definitely strictness while identifying whether it can be unfair trademark practice or whether it's really like bigger issue. They actually, the court didn't consider it in that fashion, and but still they considered that you can't put misleading information or disparage any good under just view of educating the public. So this cannot be done in that fashion. So court considered that and pointed out the Abhijit Bhansali that he should put down or take down his video so that this video is not available and it should not disparage further the uh, brand name of Marico. So this was one case. There was another case in which the liabilities of intermediary was discussed by Delhi High Court. So it's a matter of Amazon versus Amway. So as we know, Amway is a direct seller of good. Like generally, most there are direct sellers which are attached to Amway. They buy the goods from Amway and then they sell it. So what was happening is the goods were being sold on Amazon's website, and Amway claimed that probably those were counterfeited goods. So there was no solid evidence behind it, but there was apprehension that it was counterfeited good. So the first question which was raised is whether there can be a liability of e-commerce giant for allowing to sell any such products on its portal. More specifically, the issue which was raised by Amway is because it has been a direct seller, its goods cannot be sold on Amazon. So that was a contention, and they were making a contention that because of their goods being sold on their portal, it's their liability, and they should be also made liable for trademark infringement. That was the contention which Amway was putting across. So in this case, like initially, initially Amway won the case and Amazon lost the case when they put up it on the matter to the lower court, and the court identified that if direct sellers guidelines has to be looked into, in which there was a particular fashion the direct sellers good can be sold, and trademarks of direct seller can be licensed and used. So which was not with the Amazon. Definitely Amazon is not a direct seller. So the view made was that definitely they were infringing because they were not following direct sellers guideline. But the matter was then taken or appealed by Amazon in Delhi High Court. There the stand changed. So Delhi High Court disregarded direct sellers guideline. Rather, they have taken the view of principles of exhaustion of rights. That means once the goods sold to the direct seller, it's up to direct seller. They can use whatever platform to sell the goods. It need not be that they have to go by word of mouth to their nearbys and then sell it. They can use any platform to sell it, and the rights, trademark rights also with respect to it are exhausted by Amway. They can't claim that either Amazon or the direct sellers should be called an infringer because it's the unauthorized uses of their trademark which is happening. So definitely the court consider that there is no liability of intermediary which is arise because there is exhaustion of rights principle which has to be followed there. Another matter is trademark spreading. So many people, definitely you people would have heard that people used to buy domain names which may be similar or may be important domain names, and they spread over it over and over for many years. Similarly, a few people even do trademark spreading. They just for the sake of filing, they file it and they keep it with them, and maybe they use it in their negotiations or arm twisting or for whatever reason. So this matter is almost similar to that. And generally, if you people know, then there is a principle that there has to be a regular use for the mark. And if it doesn't happen for continuous 5 years, then there could be a possibility you can take the matter before the authorities and file for rectification of the mark. And because of non-use of the mark, the rectification proceeding may succeed, and the register of the trademark can be rectified, and the name of the person who was owning the mark can be removed. So these are like these kind of regulations are specifically made for people who are exploiting the trademarks. So in this case, one Hitesh Aswani, I think so. He's also known to do these activities before, but what he did is he filed for PlayStation PS5, a trademark application. And what happened is Sony had to launch it, but when they see that the application is already filed, then they do not have an option. Like they can't directly launch, because if they launch it, they would start infringing the trademark of this fellow. So what they do is they file a opposition proceeding before the applicant. So applicant was wise enough here; he didn't contest it. Rather, he just took away the like he has withdrawn the application, and with that the case was resolved. But I think so. If this case has moved to the further authorities, definitely their opposition of Sony would have been successful. And in case the mark was already granted or registered, probably it can be a good case for rectification also. So that's how trademark squatting is one principle. We have seen some kind of unique matter which has come up. Definitely, it's not a judicial one, but it was part of the trademark office process. So now I will be just dealing with few of the matters where similarity of the marks were determined by various courts. So this matter was before Delhi High Court. So here in this case, plaintiff was owning trademark named BOAT, BOAT, for consumer electronics goods. And defendant was using the mark BOULT for similar category of goods like audio gadgets, earphones, headphones. So if you will see, there is a substantial level of similarity between BOAT and BOULT. Only the difference is about A and UL. That is the difference. So the similarity doesn't end here. There were more to it. So plaintiff was using a tagline, plug into Nirvana, while defendant was using a tagline, unplug yourself. So definitely there was another level of similarity between the both taglines. So what court has taken a view is they identified, definitely there was identical nature of the goods. There was similarity between the marks and even the brands. If it has been seen, there was similarity in the representation of both of them also. So the court identified that definitely there is a subject matter where a similarity can be established, and accordingly it could be a opt subject matter of trademark infringement, and that's why they put up a restraining interim injunction against the defendant. So another case was um, Racket Bensker and Mohit Petrochemicals. In this case, what has happened is plaintiff was plaintiff owns a trademark name Dettol, and it is also registered in class 5. We know that this was a tough time last year. Now we are also again in the tough time, but at that time the sanitizers were in hype. So what this fellow did is Mohit Petrochemicals, they start using the mark Dettol for hand sanitizers. So if you will see the difference again here is the third letter T is replaced by V. So definitely there is some level of similarity between both the names. And when you see hand sanitizers are all almost in the same category in class 5. So definitely there is similarity in the goods, similarity in the names. So same thing the court has taken as a cognizance They identified that definitely there is identical nature of codes, similarity between the marks, and even the overall representation of the branch. And accordingly, they feel that it is a opt case of infringement, and then for the same reason, they put up a restraining orders against defendant, and also some damage of rupee 1 lakh was put across. But the importance is the court took a cognizance and identified similarity between the marks and the code, and put up and considered it as a infringement. Another matter is for the company delivery versus treasure based ventures. So as we know, delivery owns a trademark delivery itself for logistic services. So they provide B2B services for various companies. uh, Also, defendant was using similar mark deliver e for similar services. So if you will see, even there is some level of definitely comparison between both the marks. They may not be as similar as Dettol and Dettol, but definitely there is similarity between the marks, and there are similar services also. But what court took a view is the delivery is a generic name describing a kind of service. That is the word delivery itself, and hence it doesn't have characteristics of a enforceable trademark. So again, I would go back and take you back towards Dettol. Dettol is a coined word, so definitely it was already unique, and of course a lot of reputation has been generated for the time being. But here the court didn't take the same view. Delivery now is in the market for substantially long time, but the court didn't consider it as a unique mark. Rather, they still consider it that it is still a generic word. So definitely, when we are choosing a mark, we need to be pretty sure about what could be the consideration given by the courts in the later phases with respect to the mark. Either your mark has to become very reputable. If it becomes very reputable, then there is a possibility there could, because of the acquired goodwill for a long period of time, can get a characteristics of a enforceable trademark, but it need not be the case always. So that's what I want to bring. The fact is, while determining similarity of the mark, a lot of thought process also is given when something is considered generic and something when it is considered unique, and the other mark is considered similar with respect to it. This one is with respect to passing of mark, passing of scenarios, and more specifically with respect to whether some mark can be qualified or not. So this is a scenario which is between ITC Limited versus Nestle India. So what ITC did is ITC has brand Yippee noodles, and one of them they named as Magic Masala. What defendant did is that means the Nestle also adopted the name Magic Masala for one of its noodles. Because it was not registered by ITC, they were not able to file the trademark infringement suit. So the opportunity was to file a passing of suit against Nestle, and which they did. So what defendant put before the court is that Magic Masala is a flavor descriptor. So they were not branding their noodles as Magic Masala, but it was just a descriptor about their flavor and nothing more than that. So that means many variants they have been producing in the market, and with respect to one of the variants, they put up flavor descriptor as Magic Masala, and it was not more than that. In furtherance, they put up the point that magic and masala are two different words which are generic and which are generally being used in the culinary industry. Like word masala is pretty general, and even magic is very regularly used in the culinary industry. And when you even combine them together, they do not have any characteristics of a mark, or they do not bring any distinctiveness. That was the contention which defendants brought. So court considered that even plaintiff used the mark as flavor descriptor only. So what court said that ITC is also not sub-branding it, or like any kind of special brand recognition is not coming with the use of magic masala for their main brand Yippee. So it can again be considered only as a flavor descriptor and not as a brand or a trademark. So hence no protection can be given to this, and definitely there is no qualification as a case of trade passing off here. So that's how the court view was when they are seeing whether something has a characteristics of a mark or not. So here in this matter, court considered whether there can be how the acquired goodwill has been seen. So it was more about that. So in this case, what has happened is plaintiff, which is Plex, is into media receiving services, and they were using Plex as a brand name for it. What Z Entertainment was doing is there were pay-per-view services it was doing, and in pay-per-view services they were using the mark Zplex. So now what happened? Plex took a cognizance. They thought like maybe it's kind of Z is playing around on their goodwill. So being a unregistered mark itself, they have taken the matter to the court, Bombay High Court, and they filed a passing of suit because the mark was not registered. So the opt case was only for passing of suit. So while court was considering the matter, they considered that what should be followed is the Trinity test. So according to Trinity test, a reputation has to be established, a similarity in services has to be established, and a anticipated injury has to be established. Then only it can be optimal subject matter for passing off. So according to the code, the plaintiff was not able to uh, put up any of the facts or evidences which can prove that either of these are being uh, passed out. So definitely the most important thing was reputation. So Zplex was not Plex was not having any reputation in comparison to Zplex. So Zplex was having long years of reputation which has been established, and definitely they have the better reputation with respect to Plex. And accordingly, court identified that Plex do not have any case in the matter, and definitely they denied the passing of scenario. So acquired goodwill is always like when the court is taking the view, it can be still relative. So somebody's goodwill can be higher with respect to other person, and in such scenario, the rights of whose the person whose goodwill was higher maybe take a charge. So accordingly, the court denied the interim injunction here. Well-known mark. So in this case, ISKCON was given the well-known mark status, which is very rarely given in India because very few marks can be considered that they have achieved the status of well-known mark, and many times they are limited to few classes only. So in this scenario, what facts have been presented by ISKCON is they mentioned that the first adoption was, even though not in India, but it was long back in New York, which was in 1996. But what has happened is they have been putting up their presence in many of the countries, including India, and in due course they have built up a strong reputation, not just globally, but also in India. And then they also put across that they have been using their brand not only for the purpose for the goods or services which are for particular things, rather their goods and services are in multiple classes. So these all facts the court considered, and they identified definitely ISKCON has all the relevant elements to be considered as a well-known mark. And when they considered that it can be considered as a well-known mark, Then they moved ahead and passed a restraining order against defendant so that they further cannot use the word ISKCON for their branding. Here now next we will discuss about domain names, specifically how because like many times we have seen the trademarks has been used as part of domain names, and when you are searching online you use few of those keywords along with something else and a different website comes up, which is not just creating an issue of trademark infringement, but also it is a matter of uh, public deceiving. So many times it becomes important subject matter of trademarks also, the domain names. So in this case, the matter was of Hindustan Unilever, and there was a domain registrar against which they had moved. So like here actual here the defendant, which was a registrar, has registered few of the domain names which were having trademarks of HUL put in them. So that means it will be a domain name which will be having HUL's trademark plus something. So here court opinion was that domain name registrars were neither equipped nor authorized to indefinitely suspend domain names once registered. So first thing is they don't have technical capability to identify which can be the trademarks, which can be the domain names which should be stopped and maybe infringing a particular trademark, and nor even they are authorized to indefinitely suspend any of the domain names, because once they suspend somebody's domain name, that party becomes an aggrieved party, and it becomes difficult to balance out both the things. So what court thought that there is definitely a human element required to be involved to see the legitimacy of domain names. That is, just through online filters, you can't see that okay, this this domain name can be infringing particular trademarks. There has to be a human decision which has to be applied to see which mark should be allowed, which mark should be disallowed. Oh, sorry, which domain name should be allowed, which domain name should be disallowed. So such suspension or blocking requires serious judicial thought process, where you have to see the merits between two different people's case, and then you have to come back to a particular decision whether something should be allowed or something should not be allowed. Again, their thought process was that it is very easy to access, even though the registrar blocks a domain, it's very easy to access a blocked domain through a proxy server. Hence, such blocking do not offer much security to the other party who has been aggrieved, and also like registrant would be at issue if we do so. Reason being, if on our order they do try to restrict somebody, and the people do the through the proxies they move to these websites, definitely registrars would be always exposed to certain kind of threats of contempt proceeding, even though they have tried their best. But then again, it will be a point of question whether it was best or not, whether they have tried their best or not. So in this case, the court took the view that definitely there was uh, definitely there was not possible for domain registrar to do such kind of blocking and suspension, and they deny. So they given their decision in favor of defendant rather than Hindustan League. In another matter, again on domain names, which was with respect to Amul owners, which is Gujarat Cooperative Milk Marketing Federation and Amul franchise. But here the Delhi High Court view was very different with respect to Bombay High Court. So court opinion was that registrars have those technologies which they can use the filters, because generally they have already been using filters for the purpose of stopping contents with respect to obscenity or any words which are pertaining to illegalities. Those are disallowed to be sold. There are filters they have been using already to do so. So the similar filters can be used against in these matters where it can be used for not allowing the domain to be registered, which may be infringing any of the trademarks. So according to the court ordered that the domain registrar to suspend block domain names containing the term Amul and further restrain them to sell any such domain names. So these are the cases which I want to bring to you to let you know how the cases has been looked over by the various judicial authorities in last 1.5 years, and that's how the development has been. Now, if anybody has any questions for me, I would be more than happy to answer.
Thank you, Mr. Gaurav, for an informative session on trademarks. We now have Professor Yamini for a thank you note. Professor Yamini Chandraprabha is an assistant professor of Alliance School of Law. She holds a BA degree in economics and history from Lucknow University, and she holds a law degree from Bharati Vidyapeeth University, Pune. Subsequently, she has done her LLM in IPR from Nalsa, Hyderabad. I now request Professor Yamini to proceed with the thank you note.
It's indeed an honor for me to propose the vote of thanks. At the onset, I would like to thank all the participants for their overwhelming response and making this workshop a huge success. I would like to extend my sincere and heartfelt thanks to our distinguished speaker, Mr. G.R. Raghavendra, Ms. Bindu Sharma, Mr. Shivaraman Krishna Prakash, and Mr. Gaurav Singhal for taking out time from their busy schedules and gracing the event. I would like to take this opportunity to express my heartfelt gratitude to our Pro Vice Chancellor, Mr. Abhay Chebi, for his unwavering support for all faculties and students. Thank you, sir, for your persistent encouragement. I would like to express my gratitude to our Vice Chancellor, Dr. Anubha Singh, for inspiring and guiding us during this entire process. Thank you, ma'am, for instilling the trust in us at all levels. I would like to now extend my vote of thanks to Dr. Ray Titus, Pro Vice Chancellor, Academics and Research, for being such an exemplary inspiration. I thank Dr. Nivedita Mishra, Registrar, Alliance University, for her perpetual support. I would also like to express my sincere and heartfelt thanks to Dr. Kiran Gardner, Dean, Alliance School of Law. Opening an IPR center was just an idea, but with your guidance, we were able to make it a reality. This would not have been possible without your help, encouragement, and constant support. So thank you so much, ma'am. I further extend my thanks to the entire IT department, without whose constant support and endless effort, this event would definitely not be possible. Last but not the least, I would like to thank the entire creative team and Mr. Avinash Umesh Rao for helping us all throughout to come up with this newsletter, ACIPR Bulletin. Lastly, I would like to thank my very own faculty colleagues at Alliance School of Law for being so encouraging, motivating, and cooperative. This vote of thanks would definitely be incomplete if I do not mention my young and energetic student coordinators who take the things forward in a most professional manner. I'm sorry if I have missed somebody, but at last, once again, I, on behalf of the entire fraternity at Alliance University, would like to thank you all for gracing the event. Thank you so much. Stay safe.